Judges, are you happy for me to start by reading out a short statement?
Yes, please.
Sure. This appeal hearing is in the matter CA-014-2019 before Justice Wayne, His Excellency Justice Ali Al-Madhani, and His Excellency Justice Shamlan Al-Sawalehi, and is being held by way of video conference. Any orders or directions made after or during the course of this hearing will be issued by the registry in Dubai on the appeal bench's instructions. The appellant is represented by Allen and Overy. Lead counsel is Roger Maysfield. The respondent is represented by Taylor Wessing. Lead counsel is Tom Montague Smith, QC, assisted by Matthew Watson.
Good. Thank you. Counsel, we've noted appearances, so Mr. Maysfield, over to you.
May it please your honours. We have quite a tight timetable this morning. I was just speaking to my learned friend, Mr. Montague Smith. We've endeavoured to split up the time between us. Originally, the appeal was listed for 1.5 days. Obviously, we've only got 1 day and we've got time zone differences to contend with. I'm going to try to get through my submissions in the course of the morning and to hand over to Mr. Montague Smith in the afternoon, leaving myself with a short right of reply around about 4 o'clock. There's obviously a chance that I may overrun slightly, depending on questions from your honours. I completely accept that. I will try and keep within my time frame. If I do overrun, perhaps what can happen is that can eat into the time for my reply, so that if I run into the afternoon, I would hope it would only be in the order of 10 or 15 minutes before I hand over to Mr. Montague Smith, and I will have a shorter right of reply at the end. So, subject to anything your honour wanted to say about the timetable, that was how we're proposing to proceed.
That seems very satisfactory, Mr. Maysfield, although I must say I'm a little more optimistic than you about time, but we'll see how we go.
Very good. All right. Now, I hope the court has had an opportunity to read the skeleton arguments and supplementary skeleton arguments.
Yes, you can assume that, Mr. Maysfield.
Very good. In terms of the background to the case, it's set out at some length in the judgment of Mr. Justice Giles, and I was going to go to it, therefore, only very briefly. In short, Amira was established in Dubai in November 2009, and it carries on business as a trader in basmati rice in the region. For many years, Amira had sold rice to Kuwait Flour, entities under the control of the government of Kuwait, and the rice supply to Kuwait Flour was generally obtained from AK Global. Now, from 2014 onwards, my clients, IDBI Bank, provided credit facilities to Amira. And the terms of those credit facilities were set out in a facilities agreement dated the 11th of August 2014 between IDBI Bank and Amira. That was a term agreement, initially for a period of 12 months, but subsequently rolled over and renewed. Under the terms of the facility arrangement, IDBI Bank made overdraft facilities available to Amira and also agreed to make buyer's credits available to it with a validity period of not more than 90 days. And by a separate guarantee dated the 11th of August 2014, Mr. Chalanar guaranteed repayment of Amira by Amira of the debts due under the facilities agreement. Now, the credit facilities were formally renewed in a sanction letter dated the 8th of March 2016, and there were a number of further informal extensions. On the 11th of February 2018, the bank wrote a letter to Amira under the heading Irrevocable Payment to AK Global. And by that letter, the bank irrevocably undertook to remit funds to AK Global on receipt of funds from Kuwait Flour and on instructions from Amira coupled with necessary documentation. On the 14th of February 2018, Amira then wrote to the bank, informing it that funds had been received by Kuwait Flour and asking it to be provided with fresh buyer's credits and for the bank to remit funds to AK Global in accordance with the undertaking in the bank's irrevocable payment letter. However, the bank refused to do so, and at the outset of these proceedings, Justice Cook found that the bank was wrong to do so and ordered the bank to make payment, which the bank then did in May 2018. And at trial, Justice Giles found that the reason for the non-payment was that the Dubai branch of the bank had received an instruction from its head office to the effect that it was not allowed to issue fresh letters of credit or letters of undertaking without further permission. The Dubai branch thought that in order to comply with that instruction, it had to refuse the extension of further credit to Amira, and the judge found that that thinking was flawed, and he echoed Justice Cook's finding at the outset of these proceedings that the bank did not, in fact, have a valid reason for refusing to make payment to AK Global. Indeed, the judge went further, and he said of the bank that this was, as he put it, shabby treatment of its customer, Amira. Now, just so the court understands the position, and given that there has been a reference in my learned friend's skeleton argument to aggravated damages, the bank is not putting forward any excuse, nor is it seeking to challenge those findings of the judge or the judge's comment. But the bank would like to make it clear that the bank's actions were not in any way malicious, nor did it intend deliberately to harm Amira, and indeed there was no suggestion of any of that at the trial. Now, as at the date of the breach, Amira had a long-term supply contract with Kuwait Flour, under which it was obliged to provide rice to Kuwait Flour under contract RC-114-2016. Amira also had an umbrella purchase agreement with AK Global, under which it was required to pay for 30,000 metric tons of rice. Once the bank had refused to advance funds to Amira or to pay AK Global, Amira therefore asked Kuwait Flour to make direct payments to AK Global in order to continue to receive shipments of rice. Kuwait Flour acceded to that request, and the judge found that 17 shipments of rice were delivered to Kuwait Flour during March 2018 under contract RC-114-2016, with Kuwait Flour making direct payment. However, from the 2nd of April 2018 onwards, several meetings then took place between Amira and AK Global, at which AK Global expressed dissatisfaction with the situation. By early May 2018, AK Global had indicated that it was no longer interested in doing business with Amira. And although its rice supply contracts with AK Global were therefore already in jeopardy, on the 1st of May 2018, Amira then took the conscious decision to enter into a further sale contract with Kuwait Flour, contract RC-118-2017, to sell more rice to Kuwait Flour. Under this new contract of sale with Kuwait Flour, Amira negotiated an improved sale price, and in order to fulfill its obligations under the new 1st of May 2018 contract, on the 26th of May, Amira also entered into new supply contracts by which it agreed to purchase 13,600 metric tons of rice, initially from TIA Agro and subsequently from Impulse SR Agro.
Mr. Masefield, sorry, Mr. Masefield, could I just stop you there? There's no suggestion, is there, that the specifications for the rice to be supplied either to Kuwait Flour or acquired from the new suppliers other than AK Global were any different to the rice that was to be supplied under the previous contract or by AK Global, is there?
There isn't. It was a different rice crop. We note that, and the judge noted that. It was the 2017 crop rather than the 2016 crop.
The specifications were the same. I think it was basmati, wasn't it?
I think it was basmati rice, Your Honour. You're right.
Yes,
you're right.
Thank you. Thank you.
And yeah, it was similar to the contract to supply rice that had been in place previously. It was a continuation of the same category of business. And under the new supply contracts, Amira had to pay more for the rice than it used to pay AK Global. And on the 28th of June, AK Global confirmed in writing that it would no longer do business with Amira, and thereafter Amira used the rice that was supplied by its new suppliers to fulfill the new 1st of May 2018 contract with Kuwait Flour. At the same time, it brought these proceedings against the bank, and by these proceedings, Amira sought and obtained an urgent declaration that the bank was contractually obliged to pay $4.1 million to AK Global under the irrevocable credit. And on 16th of May 2018, Justice Sir Jeremy Cook found in Amira's favour and granted interim relief. And then on 20th of May 2018, the bank paid that money to AK Global and wrote to Amira stating that the sum would be treated as having been advanced to Amira pursuant to the overdraft arrangement in the facilities agreement. And the bank invited Amira to suggest alternative terms for its repayment. Amira never did so, and the sums have never been repaid by Amira. They are still outstanding to date, more than 2 years after the sums were advanced. The proceedings then continued in order to determine what, if any, damage Amira had suffered, and various heads of loss were initially pleaded by Amira, but were subsequently withdrawn. Thus, there was initially a claim for incurred demurrage charges, and there was also a claim for $400,000 for the costs to Amira of seeking alternative finance from other banks, but that was also dropped at day one of the hearing. And by the start of the trial, as set out at paragraph 66 of Amira's skeleton, Amira was advancing 5 discrete heads of claim, and of these, by far and away, the largest two were Amira's claim for reduced margin, a claim for just under 2.3 million, and a claim for loss of value in Amira's business as a result of reputation damage, for which it was claiming $89.2 million based on the fall in the share price of its parent company, ANFL. And for its part, the bank was advancing a counterclaim of about $6.4 million. Now, so far as those various claims and counterclaims were concerned, in his judgment, the judge found in Amira's favour on the reduced margin claim and awarded Amira the sum in the region of $2.2 million. He found partially in Amira's favour on the claim for reputation damage and awarded Amira the sum of $10 million for the damage done to its credit reputation. And the learned judge dismissed the counterclaim on the basis that the only notice of event of default that the bank had served on Amira prior to the date of filing its counterclaim was bad in law for reasons we will come on to. And by this appeal, Ground 1 challenges the judge's findings in respect of the reduced margin claim, Ground 2 challenges the judge's findings in respect of Amira's claim for reputation damage, and Grounds 3 and 4 challenge the dismissal of the counterclaim and the third-party claim against Mr. Chananor.
Sorry, Mr. Maswell, can I again interrupt? As you point out, the reduced margin claim was allowed in amount a bit under 2.2 million, the reputation claim in 10 million, but the amount for which judgment was entered was 12.6 million US, as I read the papers. Do we know that there seems to be another 400,000? Is that interest or some other?
No, Your Honour. As we understand it, there was some other claims. There was a cost of about 300,000 for the direct payments that were made by Amira to by AK Global to Kuwait Flour, and because Amira dropped out of the equation.
Yeah, the loss on those 17 contracts. Yeah. All right. Exactly. Thank you for that.
Exactly. So if I can start by addressing the court on ground 1, the reduced margin claim. Now, at trial, the bank resisted the reduced margin claim on 2 grounds: foreseeability and whether Amira had in fact suffered any consequential loss of profit. And so far as the latter was concerned, the bank pointed out that prior to the bank's breach, Amira was selling rice to Kuwait Flour at a price of $1,389 per metric ton. But after the bank's breach, Amira was able to negotiate a more favourable contract of sale with Kuwait Flour, by which it sold the rice to Kuwait Flour at an increased price of $1,549 per metric ton. And the bank said that Amira could not claim for the increased cost of the new supply contracts without also bringing into account the increased price that it was charging for the onward sale to Kuwait Flour. For its part, Amira said that the benefit of the Kuwait Flour contract did not have to be taken into account because it was a collateral or independent benefit, and the question the court had to resolve was whether the more favourable contract with Kuwait Flour was or was not something that needed to be taken into account on the assessment of damages. And in his judgment, the judge held that the head loss was foreseeable, and he said that the increased sale price to Kuwait Flour was not relevant and could be disregarded by the court in its assessment of Amira's claim for loss of profits. And so far as the latter is concerned, the learned judge did so by reference to 3 authorities in particular: Joyner and Weeks and Campbell and Mostyn Barnett, which the judge refers to at paragraph 138 of his judgment. For your honour's note, that's at page F30 in the appeal bundle. And the third case was Williams and Agius, which the judge referred to at paragraph 139 of his judgment, also at page F30. Now, Your Honours, on this appeal, we don't seek to challenge the judge's findings on foreseeability. We do, though, say the judge erred in holding that he could disregard the increased sale price to Kuwait Flour when assessing Amira's claim for consequential loss. And so far as that is concerned, I'd like to say something first about the relevant legal test for when a benefit is or is not collateral, and therefore should or should not be taken into account, then to consider the judge's judgment and where we say he went wrong with regard to the legal test, and then how the relevant legal test should be applied to the facts of the present case. Now, so far as the legal test is concerned, the question of when the court will and won't take into account a post-breach benefit is a complex one, but it's well set out in our submission by the learned authors of McGregor on damages. In short, the general rule on avoided loss is that laid down in British Westinghouse, that the claimant cannot recover generally for a loss which he has avoided by reasonably necessary means. And the rule can be stated as follows: where a claimant is seeking damages for a loss of profit, or indeed for any form of consequential loss, then a benefit that is obtained by the claimant after the breach must be taken into account when assessing damages for loss of profit, provided that two conditions are met. The first condition is that the benefit must have been obtained in the ordinary course of the claimant's business. One sees that in British Westinghouse itself, which we will look at. The second condition is that there must be a broad causal nexus, either to the breach or to the claimant's act of mitigation in response to the breach. In short, the benefit must have arisen out of the breach itself or out of action taken by the claimant in response to the breach. And one sees those two alternative tests for the broad causal nexus formulated by the Supreme Court in the new Flamenco, which we'll also look at. Now, if those two conditions are met, the ordinary course of business and the broad causal nexus test, then the benefit obtained by the claimant is not collateral or independent, but part of a continuing response by the claimant to the breach and must be taken into account when assessing damages.
Mr. Masefield, why do you describe it as a broad causal nexus test?
Because it's broader than simply causation in the sense we normally use the word causation, of flowing from the breach. It can flow not only from the breach, but from steps taken in mitigation. And those steps in mitigation can go further than what the claimant is legally required to do. Because as we will see from British Westinghouse, it's wholly irrelevant whether the claimant is under a duty to obtain the benefit, and it's irrelevant that the claimant may have gone out of his way to obtain the benefit and have entered into new contractual relationships to do so, provided it's entered into in the ordinary course of business. And as a response...
It must be in mitigation of the breach, mustn't it?
It must, exactly.
And so if the action would have taken place irrespective of the breach, then the benefit wouldn't be brought to account, would it? Correct. But you need to look at the situation that the parties found themselves in. Our point when we come to the facts, Your Honour, is that following the breach, Amira found itself in a situation where its supplier, AK Global, was threatening to withdraw the supplies of rice contracts. Amira therefore had a choice. It could either continue to trade with Kuwait Flour, in which case it might need to find a new supplier, or it could stop trading. Now, the latter would have been a drastic option, but a reasonable response was to continue trading with Kuwait Flour, and that is why Amira entered into a new contract on the 1st of May. But Mr. Masefield, that wasn't a step taken in mitigation of the loss. That was a step taken in the pursuit of Amira's ordinary business. It was in the business of selling rice to Kuwait Flour. It entered into contracts for the sale of rice to Kuwait Flour. It entered into a new contract for the sale of rice to Kuwait Flour of the same specification as would have been supplied by AK Global. The only difference is that instead of supplying rice supplied by AK Global at the price that would have been applicable had AK Global continued to supply, it was obliged to obtain rice from other sources at a higher price. And that higher price is the loss that it suffered by reason of its inability to continue to deal with AK Global. But I'm struggling to see any causal nexus between the new contract with Kuwait Flour and either the breach or any action taken by Amira in mitigation of the breach. And I think that's the heart of the issue, really, in Underground One, isn't it?
It is. Can we turn to look at the timeline which we've produced? It's a short chronology, which I think shows the response, the reason why we say it's an act taken in response. And we have that in bundle F21, page F258.
Well, I've got a copy of F262. I think it's the same one.
I'm grateful, Your Honour. So this is the reduced margin timeline. And what the court can see, we've cross-referenced this by footnotes to the relevant paragraphs in the judgment of Mr. Justice Giles. Now, the first entry is the 14th of February 2018, the date of the breach, when the bank refuses to advance funds to Amira. And the next entry notes that on the 22nd of February 2018, Kuwait Flour starts to make the direct payments to AK Global and receives the last of the rice which Amira was obliged to supply to Kuwait Flour under the 2016 rice crop contract. The judge found it delivered 17 shipments during that period, March 2018, and the judge awards Amira damages for those profits that it would have otherwise realised on those trades. But then on the 2nd of April, there was the first of several meetings between Amira and AK Global, at which AK Global expresses discontent with the situation, and the judge finds that by early May, AK Global has indicated it's no longer interested in doing business with Amira. Now, although AK Global, which was Amira's main rice supplier in the region, was expressing discontent, the judge finds that on the 1st of May, Amira then chose to enter into the new contract to provide rice to Kuwait Flour. And it was that contract which brings in the improved price. Now, we accept Amira was not under any legal obligation to enter into that new contract to provide more rice to Kuwait Flour. But once it became clear following the bank's breach that AK Global might refuse to continue to supply rice to Amira, Amira had a choice. One way of dealing with the problem of AK Global no longer supplying rice to Amira would be for Amira to stop trading with Kuwait Flour and to refuse to enter into the new onward sale contract with its customer. That would have been a drastic measure, but it was an option that was open to Amira. Another way of dealing with the problem, and this is the route that Amira chose to adopt, and we say it was a reasonable and prudent course in the ordinary course of business, which is the British Westinghouse test, we agree with Your Honour, would be for Amira to enter into a new sale contract with Kuwait Flour, but to look to see if it could source the rice for that contract from new suppliers, if AK Global subsequently decided to refuse to supply the rice. Now, both of those are reasonable mitigation responses to the situation in which...
Mr. Masefield, I don't see... Mr. Masefield, you are, with respect, repeating what you said earlier, and I'm still having trouble with it, because if you're in the business of selling rice as a wholesaler to another purchaser, then that is your business. What you do is you buy a commodity and you sell it on. I just see, Mr. Montague-Smith, are you still there?
Yeah, hi, I don't know if you can hear me now.
Good. Yes, good.
Okay, I missed about 5 minutes.
Up on my screen saying you'd left, but anyway, you can still hear us.
I've lost internet connectivity, I'm afraid. My internet provider has failed me this morning, so I've dialed back in by telephone. Hopefully I'll fix it this afternoon.
Good, all right. So if you look at there's the sales side and there's for simple terms, there's the selling side and there's buying side. If you're going to stay in business, you keep on selling the commodity. And you've got a purchaser in Kuwait Flour who, despite the ructions as a consequence of the bank's actions, is prepared to enter into a new contract with you. So that there's no, as far as I can see on the timeline or on any other basis or in the evidence, there is no suggestion that the new contract with Kuwait Flour had anything whatever to do with the breach. It was simply a contract it entered into in the ordinary course of business, under which, notwithstanding the provocations that had been provided to Kuwait Flour and the changed arrangements that had been necessary, Kuwait Flour was willing to pay a higher price. And I can understand on the sale side, on the purchase side, I'm sorry, action had to be taken because AK Global dropped out. And so new suppliers were required. But I don't see how that's got anything to do with the selling side, the sale to Kuwait Flour. So the mere fact that a contract was entered into at a new price after the breach, and the mere fact, it just seems to me to be, it's a temporal connection but not a causal one. So I can't see how the relevant profit that you want brought to account is the profit deriving from the new contract with Kuwait Flour. And I'm struggling to see any causal connection between that contract and anything done by the bank. So that's the problem I'm having with your argument.
I appreciate that, Your Honour. We say that there was a choice that Amira had following the breach as to how it should respond.
But the choice was either trade or stop trading. It was in the business of selling rice. If it was to continue its business, there was no choice derived from the bank's conduct. It wanted to continue its business. And it was able in the course of its business to obtain a revised price for its product. But the revised price for its product had nothing whatever to do with the bank's breach, did it?
In as much as it was a response to the situation in which it found itself in. The way the causal connection...
Why did you say that? Why was it a response to the situation it found itself in? It was simply the continuation of its trade, wasn't it? The response to the situation it found itself with was on the supply side. When it lost its supplier, AK Global, it had to go out and find other suppliers. That was the response to the situation it found itself in. On the sales side, it was just carrying on business, selling rice to Kuwait Flour, as it continued to do.
But
I don't understand how the sale of rice to Kuwait Flour, the new contract, had anything to do with the bank's breach.
Your Honour, I hear what Your Honour says. The authorities show that where you are in you're responding to a situation in which you found yourself, then if the steps are taken in the ordinary course of business and are part of a continuous transaction, then they are something that needs to be taken into account for the claim for consequential loss.
Mr. Masefield, I'm not quarrelling with that view of the authorities. What I'm quarrelling with is the factual proposition that the contract that was entered into with Kuwait Flour was a response to the situation in which Amira found itself as a consequence of the bank's conduct. The only consequence of the bank's conduct that I can see on the facts established in the timeline to which you referred us was the reluctance, or indeed the refusal ultimately, of AK Global to continue to supply, as a result of which new suppliers were required. But that was the situation in which Amira found itself as a consequence of the bank's conduct was that it didn't have a supplier. That the bank's conduct had nothing whatever to do with its client, the purchaser, Kuwait Flour. And so nothing that was done with Kuwait Flour was anything to do with the bank's breach. So the principle to which you refer in the authorities simply doesn't appear to me to apply to these facts.
Your Honour, timing is tight on this appeal, and I hear what Your Honour says. Obviously, you've seen the way we put the claim in the skeleton. You've heard what I have to say on the facts. But I think, given what Your Honour is saying, it may be better for me to devote more time to the other grounds of appeal than on this one, because it is a short point on the facts. I appreciate Your Lordship understands the position as a matter of law, and the question is whether, when you look at the steps that Amira took, whether they are responsive to the breach. All I would say is that when you look at cases like the new flamenco to see whether there is a response to the breach or not, you've really got very extreme facts before the court will say the causal connection is not there. So, for example, in the new flamenco, the facts there were that there was a charter party that was repudiated, and the step that was taken post-repudiation by the charterers was to sell the vessel rather than to try to carry on trading on the spot market. Now, if they had carried on trading on the spot market, the Supreme Court seems to indicate that that income stream that would have been obtained by carrying on trading on the spot market would necessarily have to be taken into account. But because they didn't do that, and instead they sold the vessel, and that was a very clear and discrete, independent decision, it was a collateral benefit. But it's that type of extreme action, which is not in the ordinary course of business, that needs to take place before the court will disregard it. If one doesn't have that, if you've got steps taken in the ordinary course of business, as per British Westinghouse itself, which flow from the breach, then you can't look at just one side of the equation. You've got to look at both sides.
The problem I've got, though, is that key phrase. I accept ordinary course of business. The problem I've got is the key phrase flow from the breach. And I'm struggling to see how, on the evidence or the findings of fact made by the trial judge, there's any suggestion that the new contract with Kuwait Flour flows in any sense from the breach of the bank. Now, just to tease that out, let me put the following factual proposition. I know you want to move on, so I'll be quick. There's no suggestion, as you agreed earlier, there's no suggestion that the rice to be supplied to Kuwait Flour was any different in specification to the rice that was going to be acquired from AK Global, had AK Global continued to trade, is there?
No, there isn't.
So that provides no explanation for the increase in price agreed to be paid by Kuwait Flour. That's right, isn't it?
Correct. Subject only to the point that it's a different rice contract for a different year.
But is there anything, when you say it flows from the breach, is there anything in the contract between Amira and Kuwait Flour, other than the fact that it occurred after the breach, which could be said in any way to flow from it, other than the fact that Amira decided to keep trading after the breach? Is that what your argument comes down to?
It is. It's that caveat to what Your Honour has just said, that Amira decided to keep trading rather than it had other areas of trade. Kuwait Flour was just one of its customers. It could have focused on those other areas.
It was its biggest customer, I think, wasn't it? On the evidence.
It was. And we say it was, we quite take your Lordship's, Your Honour's point, that it was a reasonable and prudent response to a situation where its supplier was threatening to cease doing business. But it was a response to that. And the reason the supplier was refusing to withdraw business was because of the bank's breach. So that it flows back through that. You've got the bank's breach. Yeah. As a result of that, you've got the supplier refusing to withdraw supplies of rice. And as a result of that, Amira has a choice. It can lose Kuwait Flour as a customer and concentrate on other areas of its business, or it can enter into a new contract. It does the reasonable and prudent thing. We completely accept it's a reasonable and prudent course. But it is the fact that it takes that reasonable and prudent course shows it is a mitigation response to the situation that Amira finds itself in, flowing from the breach.
Well, Mr. Mansell, sorry, please finish.
And we say that brings it within the British Westinghouse rule.
I promise that this is my last question on this ground. The but-for test we know is sometimes reviewed sceptically, but applying the but-for test to these factual circumstances and saying but for the breach, what is the position in which Amira would have found itself? Isn't the answer that but for the breach, Amira would have continued to trade with Kuwait Flour, entered into the contract on the 1st of May at the higher price, and would have continued to trade with AK Global and would have obtained rice at the lower price from AK Global under that contract, and therefore would have had even more profit. Isn't that what would have happened but for the bank's breach?
I think the trouble with that is that one's looking at the situation, the hypothetical situation that didn't arise. What you've got to look at is what actually happened after the breach, see whether that was in the ordinary course of business, and see it. McGregor makes it very clear that the test for whether the benefit is collateral is not to be answered by reference to a strict causation analysis. The paragraph in McGregor's book is 112. They say the question of whether or not a benefit is collateral is not to be answered by looking at by using the slippery slopes of causation. Can we just turn that up? So it's page just reading my notes. It's in G-1-427.
G-1-427, thank you.
Yeah. Let's see whether it's on that page. I'm sorry, it's just a few pages forward. So, G-1-429, Your Honour.
G-1-429, thank you.
Yes. Paragraph 9112. And the learned authors and McGregor say this, nor is understanding the third rule of mitigation assisted by climbing the slippery slopes of causation. In his analysis of mitigation in terms of causation, in the Elena D'Amico, Mr. Justice Robert Goff applied the analysis to the third rule as much as the other two, and it is considered that it is of no greater use here than it was found in relation to the central first rule or to the second rule. The test in relation to the third rule, as we shall see, is variously constituted and described. It may be said to turn upon whether the benefit comes from an act taken in consequence of the wrong, whether the benefit arises out of the act of mitigation itself, whether the act giving rise to the benefit forms part of a continuous transaction, starting with the wrong. The test is again not causation. So, Your Honour, if the court were to adopt a strict causation test, we suggest that that would be wrong when you look at the case law, and McGregor expands upon that by reference to the cases and shows that there is a broader test using the terminology described here. And we say that there is the benefit that was obtained under the Kuwait flour contract does form part of a continuous transaction starting with the wrong, and that it was in the ordinary course of business. And that being so, the rule falls within British Westinghouse. But, Your Honour, I'll move on.
Yes, before you do, Mr. Maxwell, I just might ask my judicial colleagues whether they have any questions of you in relation to ground one. No? No? All right. Move on, if you'd like to move on then, Mr. Maxwell. Thank you.
I didn't have one yet, thanks.
Thank you. Thank you, Mr. Maxwell.
I'm grateful. Your Honour, that was all I wanted to say on the reduced margin claim. If I can turn to the second ground of appeal and the sum awarded by Mr. Justice Giles under the heading loss of value of Amira's business, which is paragraphs 151 and following the judgment. And I want to start again by saying something about the law and then to consider the result the court should have arrived at, we say, if it had identified and applied the correct legal principles. So starting with the law, under English law, the position is, we say, clear. Where a bank dishonors a check or wrongfully refuses to advance credit to its customer, it's well established that the customer can bring a claim for two types of damage. First, the customer can bring a claim in general damages under the first limb of the rule in Hadley and Baxendale for damage done to his credit reputation. And because that is a claim for general damages, the customer need not plead or prove any special damage or loss of business. In such a case, the award made by the court is not an award for loss of business, it's an award for the damage done to the customer's credit reputation, and it's been said to akin to an action in defamation. And the courts have consistently emphasised that when assessing damage to credit reputation, the customer is entitled to more than nominal damages, but absent proof of any special damage, the damages awarded by way of general damages must be kept both reasonable and temperate. And in none of the cases where such general damages have been awarded has an award been made that is greater than $450,000 US. Indeed, in most of the cases, the damage to the claimant's credit reputation has been assessed in the order of $20,000 to $30,000 US. Second, and quite separate from the claim for general damages, for damage done to the credit reputation, a customer can bring a claim for specific loss of business flowing from the wrongful dishonour of the cheque or the refusal of the credit. But such a claim has to be specifically pleaded and proved by the claimant at trial in the usual way and under the second limb of the rule in Hadley and Baxendale. And if the customer fails to plead and prove that specific loss to the satisfaction of the court, then he has to fall back on his claim for reasonable and temperate damages for the damage to his credit reputation. And one sees that distinction neatly drawn in our submission in the decision of the Court of Appeal in Corpororo and Woolwich Building Society, which we have in bundle G1 at tab 17. And that was a case where a customer carried on business as an exporter and importer to Nigeria, and a cheque was wrongfully dishonoured by the bank. The customer brought a claim both for general damages for the injury to his credit reputation and for special damages for loss of business, the contract in that case with a Nigerian purchaser, which the customer claimed had fallen through as a result of the wrongful dishonour of the cheque. At first instance, the claim for special damage for loss of business, which was just shy of £60,000, was found to be too remote and was dismissed. But the claim for general damage for injury to credit reputation was allowed, and the customer was awarded damages of £5,500. The bank appealed on the claim in general damages, and the customer cross-appealed on his claim in special damages, and both appeals were dismissed by the Court of Appeal. And we can pick it up in the authorities bundle at G1, page 226.
Mr. Macefield, I don't want to take you off course, but I'm struggling to see the reason we're going to this case, because it's common ground, isn't it, that the judge assessed general damages only, that is damage to reputation. And I don't think there's any issue about that as I read the skeletons. Your proposition is that he awarded far too much.
Correct.
So I'm not sure that looking at the different categories is going to help us, is it?
It's not. There is. I'll move on, Your Honour. I'll move on more because we can take this more quickly. Okay. So. It is worth looking in our submission at the first case in this area, which the House of Lords in Credit Company in United Bank in Wilson has held was the correct direction of how these damages are to be assessed. And that's the decision in Rowland and Stewart. And that is authority as well for the proposition that this type of claim is akin to an action in defamation. And it shows that when the court quantifies the loss to credit reputation, the award of damages should be, in the words of Lord Campbell, not nominal nor excessive, but reasonable and temperate. And we have Rowland and Stewart at tab 8 in bundle G1, starting at page G1 142. And we can see from the head note, the court held in that case that substantial damages, by which it means more than nominal damages, may be recovered against a banker for dishonouring acceptance and checks of a customer, there being sufficient assets in his hands for the time to meet them. Now, in that case, the jury had returned a verdict for the plaintiff of £500 by way of damages, and on appeal, the decision to award substantial as opposed to nominal damages was upheld, but the sum was reduced to £200 on the grounds that the £500 figure was excessive. And we can pick it up at page 249 within the report, that's page G1 146. And we can see that there the judgment, 2/3 of the way down the page, we have the judgment of Mr. Justice Cresswell, and he says, "It appears to me that the direction of my Lord Campbell was perfectly right. He told the jury that they ought to give not nominal nor excessive, but reasonable and temperate damages. And it was that direction which the House of Lords subsequently endorsed in Wilson and United Counties in 1920 as being an accurate statement of the law." And then over the page, at page G1 147, we have the judgment of Mr. Justice Williams, and he says he's of the same opinion as his brother judge, Mr. Justice Cresswell. He says this: "As to the alleged misdirection, I think it cannot be denied that if one who is not a trader were to bring an action against a banker for dishonouring a cheque at a time when he had funds and customers in his hands sufficient to meet it, and special damage were alleged and proved, the plaintiff would be entitled to recover substantial damages. And when it is alleged and proved that the plaintiff is a trader, I think it's equally clear that the jury, in estimating the damages, may take into their consideration the natural and necessary consequences which must result to the plaintiff from the defendant's breach of contract. Just as in the case of an action for slander of a person in the way of his trade, or in the case of an imputation of insolvency on a trader, the action lies without proof of special damage. I think, therefore, the direction was right. And so we say that establishes the broad principle that a claim for damage to credit reputation is a claim in general damages. It's akin to an action for slander or defamation, and as such, the action lies without proof of special damage, but the amount awarded must be not nominal nor excessive, but reasonable and temperate damages, in the words of Lord Campbell's direction to the jury in Rowland and Stewart. Now, in all these cases, Your Honours, the customer is being compensated for the damage done to its credit reputation and its loss of standing in the business community. And a reasonable sum can be awarded for that. But apart from the present case, there has been no reported case, either in England or Wales, or as far as we're aware, in any Commonwealth jurisdiction, where a claimant has been awarded as much as $10 million for the damage done to its credit reputation, or indeed anything approaching that figure, even when adjusted for inflation. And we set out in our skeleton argument a review of the key authorities, and we can see them at Bundle F, tab 4, at page F118.
Yes, well, again, Mr. Masefield, I assume we've read the skeleton, we've read those cases. We understand that your submission is that this award is well outside the ordinary range. I'm not sure that delving down into individual cases is going to help a great deal. What I would find myself more helpful is an analysis of the evidence, or at least what you say I think is the paucity of the evidence, to support an award of anything approximating $10 million in this particular case.
Absolutely. I'll come on to that in just a moment, Your Honor. Before I do that, I won't go through the cases, but three things are said against the line of authorities by my learned friend that he says are reasons why they can be distinguished in his appeal. I'd just like to address those propositions. The first thing is, it said that these are old and antiquated cases. The suggestion apparently being that if a case were now to come before the English courts, a more generous award for general damage to credit reputation might be expected. The second, it suggested that in each of these cases, the size of the dishonoured cheque or credit was relatively small, the argument being that the larger the credit facility in issue, the larger should be the award to the injury to credit reputation. And the third point that it's made is it's suggested against me that in each of these cases, the turnover of the company or individual was relatively small, the argument being that if a corporate customer has a large turnover, it should be entitled to a larger award for the harm done to its credit reputation. And we say, with great respect to my learned friend, that none of those arguments stands up to scrutiny. I'd just like to explain why shortly before we come to the evidence, my lord. Starting with the first, the suggestion that these are old and antiquated cases, we'd obviously accept that that is true of some of the cases we referred to, for example, Rowland and Stewart and Larius and Geraghty, but modern cases have gone out of their way to endorse as correct the principle expressed in the early cases. That is true by the Court of Appeal in the Corpora Law decision in 1996, where Lord Justice Evans quotes with approval Lord Campbell's direction to the jury in Rowland and Stewart. And he noted in 1996 that it had been said by the House of Lords and Wilson and United Counties Bank to be an accurate statement of the law. And if anything, when one looks at recent authority, the courts have been anxious not to allow corporate customers to claim large sums by way of general damage for damage done to their business reputation. That one sees that not just in corporate law, but also in a defamation case decided in 2007, the case of Jameel and Wall Street that we have referred to in our skeleton argument, where the House of Lords had an opportunity to consider whether in a case involving libel of a company, the company which has been libelled should be entitled to claim general damages without the need to plead or prove special damage. And the House of Lords, in that case, Lord Bingham, speaking for the majority, rejected an invitation to reform the English law of defamation and say that specific loss had to be established. He accepted that a claim in general damages could lie without proving specific loss, but he emphasised that a company should only be able to recover when it can point to no actual financial loss. Damages should be kept strictly within modest bounds. And we say in our submission that's a clear statement in 2007 by the House of Lords of the modern position under English law. And what is interesting to note, it almost precisely echoes the remarks made some 150 years previously by Lord Campbell when directing the jury in Rowland and Stewart. If you can't prove specific loss, you can get general damages, but the award must be temperate and reasonable. So we say there is nothing antiquated about the approach one sees in the authorities we've cited. It represents the modern approach that one sees reflected in the broader context of defamation cases. The second argument put forward by my learned friend, that the true pattern of these cases is revealed by comparing the damages awarded to the size of the dishonoured cheque or facility, is also misconceived at two levels. Firstly, there is no such pattern when one looks at the cases themselves. In some of the cases, such as corporal law, the sum that's awarded by the court is roughly the same as the value of the dishonoured instrument. But in other cases, such as Davidson and Barclays Bank, the sum awarded is 125 times the value of the cheque. And what is, however, striking about all the cases that one looks at them is that the sums awarded are not said to be referenced to the size of the facility. Rather, it is repeatedly said that the awards must not be excessive, that they must be temperate, reasonable, and modest. And that is what one sees. The second reason why the argument is fallacious is that when one stops to think about it, logically, there is no reason for there to be a connection. In all of these claims, the company or individual is claiming damage done to its credit reputation. And the harm done to the reputation is not to be measured in any case simply by the size of the cheque. Relevant factors may include how widely the bank publicised the fact that it was dishonouring its customer's cheque or refusing to extend credit. And another relevant factor may be for the court to consider how well established was the company's credit and standing previously. But the size of the credit facility that's been refused is unlikely to reflect the damage done to a particular customer's reputation. If anything, quite the reverse. If I draw a cheque for $1 million that is wrongfully dishonoured by the bank, the inference drawn by others in the business community is likely to be that I do not have $1 million readily available in liquid funds, but that my credit may still be good for lesser amounts of money. Whereas if I draw a cheque for a few £100 that is wrongfully dishonoured by the bank, the slur on my credit reputation is in fact considerably worse, since the inference is that I do not even have that much lower sum available in liquid funds, at which point many other creditors may start clamouring at my door. So we say that the argument based on looking at the size of the facility and saying the greater the facility, the greater should be the award of damages for credit reputation, just does not hold water. The final argument, that the figures are explicable by reference to the turnover of the corporate or personal business in each case, also does not stand up to scrutiny. When one looks at the cases, there is no suggestion in any of them that the award of general damages has been fixed by reference to the scale of the claimant's business interests, nor is any such pattern discernible in the cases. And again, when one stops to think about it, one would not necessarily expect there to be such a connection as a matter of logic. A company with a large turnover may still have a lousy credit reputation, which would not be significantly injured when a particular cheque is dishonoured. Equally, a company with a small turnover may previously have enjoyed a strong credit reputation, such that a dishonoured cheque might have more serious consequences for that company. Each is likely to turn on its own facts. And when one looks at the modern cases in defamation, if anything, one sees the court saying that the larger the business, the more it should be thick-skinned, and the more it should be able to withstand slurs to character than smaller companies or individuals. One sees that in the Jameel and Wall Street case, and one also sees that in the infamous McLibel litigation decided in 2005, where the English courts held that the McDonald's hamburger chain was entitled to an award of only £40,000 for alleged harm to its reputation. And even that modest figure was subsequently said by the European Court of Human Rights to be a disproportionate and excessive award, because the European Court said large companies can be expected to be able to withstand even wrongful criticism. So if anything, we say the larger the multinational corporation, the more it should be able to cope with slurs to its character. And there is nothing in the English or Australian or Commonwealth authorities that suggests that companies with greater turnover should be entitled to greater protection. Now, turning to the facts in the present case, so far as the claim for damages was concerned, at trial, Amira pleaded its case in two ways. We see this at, if we take up bundle A, page A53, where we have the particulars of claim. And if we turn on to page A56, paragraph 16, we can see how Amira formulated its heads of loss. And the first item of relief was the one that was granted by Mr. Justice Cook. Then the next two items of relief, 16B and C, are the demurrage charges and the cost of alternative finance. Those were both dropped either before or at the start of the trial, and Amira did not pursue them. It had previously quantified the claim for seeking alternative finance at $400,000 US, but in the event it did not pursue that claim at trial. There are then two items of relief, 16D and E, which we can come back to in a moment, which are the relevant heads of loss, and Amira ended up running those together. And the only other head of loss pleaded by Amira was item 16F, which was the profit that it said it had lost as a result of Kuwait Flour paying AK Global directly on the 17 shipments. And for that, it was awarded $303,500 US, and we don't seek to appeal that finding. So what one is then left with is claim 16D, which is the claim for reputational damage, and then there was a claim 16E, which was that Amira had been unable to develop its business with Kuwait Flour, which is a major regional purchaser. And that was it in terms of how Amira had pleaded its case. Now,
Masefield, at trial, the case, sorry, Mr. Masefield, at trial, the case was put much more broadly than that, wasn't it? So that at trial, the primary basis of Amira's claim was said to be measured by the drop in the share, in the market capitalisation of its parent. So Amira doesn't seem to have been confined to these particulars at trial, was it?
That's correct. So it tries to, what Amira does is it tries to evidence the loss that it has suffered and damage to its reputation by reference to the share price movement. And also, and we'll come on to this in a moment, by a table in Mr. Gandhi's witness evidence, which included some sales projections, not based on internal accounts, because those haven't been disclosed, which indicated that there might be a fall off in trade in 2019. And I'm just coming to those, Your Honour. Now, in terms of the evidence at trial...
Sorry, Mr. Masefield, just before we leave this, just looking at paragraph 16, when I look at D and E, they don't, or indeed F, they don't seem to cover the claim that was eventually presented at trial. The claim presented at trial was for general damage to reputation, not just for the identified parties in D, E and F. So something must have happened between the filing of these particulars of claim and the trial, mustn't it? Is there another document expanding the claim, or was it simply...
Schedule 1 to the reply, which goes further, although it wasn't an amendment to the particulars of claim, but we can turn that up, Your Honour. We've got that in bundle A at 7. And if we turn to the back of that document, Schedule 1, so I'm just trying to find the page. I believe it may be A91, I'm grateful.
Yes.
We've got Schedule 1, which sets out the loss that the claimant was claiming on the various heads. And one can see that it deals with direct costs in paragraph 2. Then the cost of establishing alternative financing, which were quantified at 400,000, as I've said, that was dropped on day 1. Then loss of opportunity, which was a shipment of, it's the reduced margin claim, then the Bangladeshi buyer, and the share price, the fall in value of ANFL's share price.
And the trial judge rejected the claim in relation to the Bangladeshi buyer, didn't he?
He did, which is the soybean contract. He also says that the share price claim is unconvincing. We'll look at that. Then there's a claim for loss of management time, then loss of reputation, separately pleaded, although, as we've seen, it is presented differently at trial. And then, excluding that, the losses are put at 1.8 million.
Yes, all right. So it's really that loss of reputation claim that was advanced, wasn't it? And that's what His Honour has given $10 million for. Correct.
Yeah,
thank you.
And now, in terms of the specific lost business at trial, we've seen one way of putting it was originally Amira was saying that it was unable to develop its business with Kuwait Flour as it had hoped. But at trial, no evidence was in fact led by Amira to make good that pleaded allegation. Amira did not disclose correspondence from Kuwait Flour, which suggested that Kuwait Flour was unwilling to develop its business with Amira, and nor did Amira's witnesses, Mr. Chananar or Mr. Gandhi, identify any specific business that was lost with Kuwait Flour. On the contrary, as we saw when we were looking at the reduced margin claim, following the bank's breach on the 1st of May 2018, Amira was in fact able to enter into a new contract with Kuwait Flour to supply it with large quantities of rice, and to do so at a higher price than the contract it had obtained previously. So none of that in our submission suggests that the bank's refusal to honour the credit facility in February 2018 had prevented Amira from carrying on business with Kuwait Flour. On the contrary...
Sorry to interrupt. It's Mr. Watson here, Mr. Montague Smith Jr. I've just been told by Mr. Montague Smith that he's been dropped out of the call and isn't able to get a dial-in number. I don't know if anyone from the court registry is able to send him a dial-in number to allow him to access the meeting. I'm sorry to Mr. Maysfield for interrupting his submissions.
I'll send you the dial-in details by way of email.
Yeah, thank you, Mr. Watson. Mr. Maysfield, I think you better just hold your horses for a little while until we get Mr. Montague Smith back.
Hello, it's Tom Montague Smith. I'm afraid Virgin Media, which is my internet provider, is suffering a service interruption in my area, which is causing the problem for me. I'm really apologetic. There's just literally nothing I can do about it. I dialed in the first time and have been booted out, but I've just dialed back in again, and hopefully that will keep me in for the next hour or so. I apologise for the interruption.
How much? Do you have any idea how long ago it was that you dropped out, Mr. Montague Smith?
About 3 minutes.
All right. Well,
shall I recap briefly?
if you could, thank you.
Yeah.
Thank you.
Mr. Montague Smith, obviously, if you drop off again, please let your junior know, and hopefully we can pause and reconnect you. What I was just saying to the court was we were turning to look at the evidence before the court at trial as to the loss of the impact to Amira's farm and its credit reputation. And one of the ways in which the claim had been pleaded at 16E was that Amira had been unable to develop its business with Kuwait Flour, which is a major regional purchaser. And the point I've been making was that at trial, no evidence was in fact led by Amira to make good that pleaded allegation. In particular, Amira didn't disclose correspondence from Kuwait Flour, which suggested that Kuwait Flour was unwilling to develop its business with Amira. Nor did Amira's witnesses, Mr. Chananar or Mr. Gandhi, identify any specific business that was lost with Kuwait Flour. On the contrary, when one looks at the documents that were produced, which we looked at in the context of the reduced margin claim, following the bank's breach on the 1st of May 2018, Amira was in fact able to enter into a new contract with Kuwait Flour to supply it with a large quantity of rice at a higher price. And we say that none of that suggests that the bank's refusal to honour the credit facility in February 2018 had prevented Amira from carrying on trading successfully with Kuwait Flour. On the contrary, following the bank's breach, Amira was able to carry on trading with Kuwait Flour and indeed to do so at an increased contract price. Now, in terms of other specific lost business, at trial, Amira advanced evidence in an attempt to suggest it had lost two particular contracts as a result of the bank's breach, neither of which were with Kuwait Flour. The first such contract was a soybean contract with a Bangladeshi customer that Your Honour, Mr. Justice Wayne Martin referred to earlier. The judge rejected that claim at paragraphs 143 to 150 of his judgment, which we have at page F31 and following, and he noted that the evidence in relation to that claim was, as he put it, scanty. And at paragraph 150 of his judgment, the judge held that the claim had not been established, both because the talks with the Bangladeshi customer were too tentative and because the causal link between the bank's default and Amira's inability to obtain alternative credit had been insufficiently proven. One sees that at pages F32 to F33. The second contract that was specifically referred to was a Seychelles trading company said by Mr. Gandhi to be another of Amira's key clients. And the judge rejected the evidence in relation to that claim at paragraphs 165 to 166 of his judgment at page F36. He said Mr. Gandhi's evidence in relation to that claim was in a number of respects unsatisfactory, and noted that the highest that the causal link could be put with the bank's breach was that the Seychelles trading customer was lost probably as a result of reputational damage. And again, no documents were produced between Amira and the unnamed Seychelles trading company to back that loss up, nor was any evidence adduced about the profitability of Amira's trades with the alleged Seychelles trading company. And as we've seen when we looked at the particulars of the claim, no head of loss was in fact asserted by Amira in relation to the loss of the Seychelles trading company. And at paragraph 166, the judge noted that Mr. Chananar's assertion of lost confidence of suppliers, customers, and other trading partners was not backed up further explained. And indeed, as the judge noted, if anything, it was actually contradicted by what little evidence there was before the court, including the improved Kuwait Flour contract. In addition to that,
Mr. Mansfield, does it come down to this? And I don't want to interrupt you, but I think we might be able to cut to the chase. The evidence that seems to me to have supported this head of claim, the head of damage, was the loss of business with AK Global. It seems a fair inference that AK Global ceased to trade as a result of the difficulties that were experienced due to the bank. So that's one head. There's also evidence that the bank published to other banks the dishonour, the lack of credit of Amira. So but that I think is the extent of the evidence with respect to publication. And then there is evidence consequent upon that from some of Amira's witnesses to the effect of the difficulties that they had in obtaining alternative sources of finance, including facilities for buyers' credits, although in the result another alternative source of finance was ultimately found. Then there's the Seychelles and the Bangladesh issues that you've already taken us to. There's Mr. Gandhi's evidence of the reduced projected profit of equivalent of 23 million US, and there was the allegations about the drop in the share price that were comprehensively rejected by the trial judge, and which doesn't seem try to be resurrected on appeal. And perhaps this is more of a flag in the ground for Mr. Montague Smith when his turn comes. But that's it, isn't it? Have I missed anything?
Exactly right, Your Honour. And just running through those helpful categories from Your Honour, the first was the AK Global drop-off in business. Well, that we say is recovered by the reduced margin claim. They've already made recovery of 2.2 million with that because they had to source the supply from elsewhere, and there would be an element of double recovery if they were to start making further recoveries in relation to that.
Well, except that AK Global could have continued to supply indefinitely, whereas the 2.2 million was in respect of specific contracts, that is, those that AK Global failed to perform. So I think the argument...
Your Honour's right, but there must come a point in time where the bank's breach in February 2018 ceases to have sufficient causative potency. We say we can see that for the reduced margin claim, but once you're beyond the reduced margin claim, looking forward, really one is trying to bill our client far too much for things that are too far down the road. In terms of the second head of loss, publication to other banks, Your Honour is quite right. The only real evidence of dissemination, and we've referred to this in our schedule that we put together for the court, was to other banks. There was no public statement by the bank or by Amira about the bank's breach. If anything, both parties seem to have wanted to keep the situation pretty quiet. The bank was obliged to make reports, and it did make reports to the Reserve Bank of India, but that was it. And Amira said that may have led to problems in seeking to obtain alternative finance. As Your Honour says, in fact, ultimately they were able to obtain alternative finance. They originally had a separate claim in $400,000 US for the cost of seeking alternative finance, but they dropped that at trial. And we say they can't try to resurrect that now by bringing it in through the back door as part of the general claim for damage to business reputation. There were then, as Your Honour said, the Seychelles and Bangladeshi contracts, which the judge rejected as too scanty. And that then left them with the two pieces of evidence that Your Honour has referred to, the drop in the share price of the parent and Mr. Gandhi's sale projection figures, which hadn't previously been heralded in the particulars of claim as something that would be relied on, but really was brought into play at trial once it became obvious that the arguments based on the fall in the share price of the parent weren't gaining a lot of traction. And what the court needs to bear in mind is that in the run-up to trial, Amira had refused to disclose either its audited accounts or its unaudited internal accounts. And the judge noted that at paragraph 167 of his judgment, which we have at page F37, when he said that his ability to assess any loss of business to Amira was, in his words, compromised by the lack of accounting information in the nature of decline of sales. And the court should also note in this regard that under clause 13.1a of the facilities agreement, Amira was contractually obliged to keep and produce audited accounts and to provide those to the bank on an annual basis. It was also required under that clause to provide its internal management accounts to the bank on a quarterly basis. So it should have had those documents to hand and available. But in breach of contract, Amira did not disclose those documents. It didn't provide them under its contractual obligation, and it didn't disclose them when ordered to do so by the court. And it offered no explanation.
Sorry, Mr. Just in relation to that court order, and I've seen that reference to that in the materials, was any enforcement action taken in relation to the failure to perform that order?
I didn't appear below, so I will ask my instructing solicitors to correct me if I'm wrong, but as I understand it, no, there wasn't enforcement action taken. The matter proceeded to trial, but obviously we say it is something that the court could and should have taken into account as part of its discretion. Normally, if people don't produce documents or witnesses without proper explanation, you're entitled to draw an adverse inference from their failure to do so. And we say that one could properly be drawn here, because the result was that Amira was then thrown back onto its two proxy arguments to try to establish its loss. Firstly, the fact that the parent company had suffered the diminution in its share price, and secondly, the table in Mr. Gandhi's evidence. Now,
sorry, Mr. Baswell, I've got some questions about Mr. Gandhi's table. Are you going to take us there in due course?
I am. I'm just coming to that. If I can just deal with the share price fall first. Now, in relation to that, the judge found there were numerous problems with that way of putting Amira's case, and he said that it had been convincingly demolished by the bank's expert. My Lord, Your Honour, I just had it confirmed that there was no enforcement action taken in a trial for the failure to disclose. So the share price, the judge noted, one sees this at F33, paragraph 154 of the judgment, that Amira's own expert, Mr. Peters, could not say that the fall in the share price of Amira's parent company was a measure of loss to Amira. Mr. Peters had noted many other matters could affect the value of shares in a public company, and that he had not been provided with anything to evidence a causal link between the revocation of the irrevocable letter and the fall in value of the shares. And the judge then noted at paragraph 156 that the bank's expert, Mr. Preacher, agreed with the limitations identified by Mr. Peters and elaborated on them. In particular, Mr. Preacher noted Amira's performance was only 43 to 63% the size of ANFL by revenue. There was no evidence of company announcements or press releases connected to the bank's actions, and if anything, the table exhibited to Mr. Peters' report suggested that historically there was little correlation between the financial results of Amira and ANFL. And the judge said at para 157 that he found these demolitions establishing Amira's claim through the market price to be convincing. And the judge then turned to see how the case had been put at trial and to Mr. Gandhi's evidence. Now, so far as that was concerned, there was one table in Mr. Gandhi's evidence, and it was only one, whereby Mr. Gandhi had referred to previous sales and projected sales. If we could just turn that up, it's in bundle B.
Yes. So B41, I think, Mr. Masefield.
B41, I'm grateful, Your Honour.
At least there may be different numbering. I may have a different version of the bundle, but it's paragraph 8 of Mr. Gandhi's statement anyway.
I'm grateful. Exactly so. Exactly so. And what one sees set out there is Amira's revenue and gross profits for various financial years.
Well, could I just stop you there? Just stopping you there, Mr. Masefield. Was there any further evidence or cross-examination on what gross profit means?
There wasn't, Your Honour.
Gross profit can mean a lot of different things to a lot of different people. It can simply be the difference between revenue and cost of goods purchased.
Exactly.
And it may not take into account all the other costs of running a business. So that we just don't know what that means, do we?
We just don't know, and the material, the underlying material, wasn't produced. And more importantly, Your Honour, when one looks at the right-hand column in that table, one sees in the top row the word projections. Does Your Honour see that above that box? And there was some examination about that. In fact, that was re-examination by my learned friend, Mr. Montague Smith, of Mr. Gandhi. He asked him about that, and the response that Mr. Montague Smith got was that these projections were based on sales targets. It was nothing more concrete than that, and the judge refers to that in his judgment, that it was just projected sales targets. So this was the course of 2018 itself, It was targets by the sales team rather than any hard accounting evidence. And of course...
Now, Mr. Maswell, sorry, Mr. Maswell, just a couple more questions. The table refers to financial years. Do we know what the financial year of the company was, what Amira's financial year was?
I will ask, Your Honour. I'm afraid I don't know offhand when. Mr. Montague-Smith might be able to help when it drew up its accounts, but I think the last accounts that we'd had from Amira were for several years back. I don't think we'd even had the 2017-18 accounts.
Well, I'd just be interested to know what the period of each financial year was, whether that was in evidence. If it's not in evidence, then I don't want people to tell me from the bar table, but I'd like to know if there's any evidence about what the periods of those financial years were, because you see, if you go to the financial year 2017-18, the most common financial year in Australia, where I live, is a year ending 30 June, and I understand that varies around the world. But if it was the year ending 30 June 2018, then of course it would have included some of the period after dishonour, and yet there appears to be some drop in whatever gross profit is. But if the dishonour was in February, you know, one would just be interested to know what part of 2018 was captured within that period of gross profit, so in order to ascertain how much of the period post dishonour it caught. And then, of course, you've got the same question arises in relation to 2018 and 19. The trial, I believe, was in July of 2019.
It was.
So the question then arises, well, by July 2019, presumably there would have been hard data in relation to at least some of the 2018-19 year. Why are we referring to projections rather than whatever data there was in respect of sales? And that's really the point, another point you're making, isn't it?
Exactly that. And it was in Amira's gift to provide that evidence. And when one looks at what McGregor has to say on certainty of damage and how one goes about pleading, proving your case at trial, of course there are cases where it may be difficult for the court to assess damages, and difficulty doesn't mean that the court is prevented from assessing damage, but it's still incumbent on the claimant to plead and prove his case and to provide an adequate data set for the court to allow the court to assist it. The claimant can't just simply throw itself on the mercy of the court and say, I say I've suffered a loss, it's up to you to quantify it. I don't know whether I need to show you, Your Honour, the passage in McGregor that makes good that proposition.
I'm familiar with the principles, Mr. Masfield.
Yeah. And we say that's reflected as well in Article 11 of the damages law in the DIFCC. Under Article 11.1, the plaintiff has to prove that he has suffered harm in respect to the particular head of loss. And under Article 11.3, provided the plaintiff has shown that he has suffered harm, the court then has to try to assess that, and it has some discretion, just like the English and the Australian courts do, to help the plaintiff. But the point is, that is not an open-ended discretion. The claimant still must try and bring the adequate data before the court. And if the claimant doesn't do that...
Yeah. Your proposition is that the discretion under 11.3 is enlivened once the claimant has gone to the boundaries of available evidence, and this claimant didn't. That's really what you're saying. Yeah.
Exactly so. And so, for all those reasons, we say, with great respect to the learned judge, that the award of $10 million by way of general damages for injury to credit reputation was excessive. It is out of kilter with the scale of the awards one sees in the earlier cases, and we've set that out at some length. On top of that, when one looks at the evidence that was available before the court, it was scanty for reasons entirely of Amira's own making. The only concrete evidence of specific trade losses, each of those was rejected by the judge. The attempt to use the proxy of the share price of the parent was convincingly demolished by the bank's expert, and all that Amira was left with was this one table in Mr. Gandhi's evidence, which wasn't backed up by accounts as it should have been. It was based on sales projections. As Your Honour has said, it's not even clear where the year end falls, and it's not clear why it was being put forward as sales projections when come the trial, one should have had concrete evidence available. And in those circumstances, we say that 10 million was an excessive award, that the learned judge should have quantified the claim for general damages at a much lower sum, and in our submission, the right sum would be, to keep it in line with the cases that we have referred to, would be something in the order of between 25,000 to 425,000 US dollars. To go much above that without clear proof of specific loss based on a proper data set, we say was an excessive award, and we would therefore invite the court to reduce it to a figure within that range.
Yeah. I keep on muting myself. I'm sorry. We're approaching the scheduled time for a break. Would this be a convenient time to take a break?
It would. It would. If we can pause there and come back in 15 minutes. Sorry.
15 minutes?
Yeah, 15 minutes.
15. Yes. Is that convenient to everybody? And Mr. Montague-Smith, hopefully, you'll be able to rejoin us.
Yes, well, I'm listening along. It doesn't look like the internet problems will be resolved quickly, but I shall go and check on it.
Okay, good. Thank you. We'll adjourn for 15 minutes. Thank you.
Very good.
I suggest everybody, we might just leave all the lines open rather than run the risk of not reconnecting. So we'll just leave everything open.
Yes, I agree.
I'll put mute on.
Yes, me too. I'll just inquire if we're all reassembled. Mr. Montague-Smith, you still there?
I am, yes.
Good. And Justice Shamlan, are you there as well?
Yes, I am here. Thank you.
Good. All right, I think we're ready to go, Mr. Masefield.
I'm grateful, Your Honours. Just before the break, Your Honour raised the question of the financial year end for Amira and the accounts, and we've had a look over the break. We know that the parent company, ANFL, filed group consolidated accounts for the year ending 31st March 2018. We have that, Your Honour, at bundle D2, page 101. And if one goes to D2 101, one's got the filing for Amira Nature Foods. And if one goes forward to D2 104, one can see that there's a table setting forth their significant subsidiaries as of March 31st, 2018, which is the year-end date. And one can see included within the table is Amira Seafoods International, DMCC, in the UAE. That's the claimant company. So it would appear that for the purposes of the consolidated accounts, certainly, that Amira was required to provide the information to its parent as at 31st March 2018 to allow it to be, those results to be incorporated into the consolidated accounts. Now, I'm afraid beyond that, we've not been able to ascertain whether Amira Foods International DMCC had a different year end or whether it kept the own year end. We'll continue to look into that, but even if it was a year ending at 31st of March 2018, given that that post-dated the breach by some 6 weeks, one would expect some
I'm sorry,
financial...
Mr. Masefield. Sorry to interrupt. I've just been told Mr. Montague-Smith dropped off again. I'm very sorry and to your honours for the interruption. Hopefully he'll be able to reconnect in just a moment.
Mr. Masefield, while that's happening, and I'll repeat this when Mr. Montague-Smith comes back, but just to go back to Mr. Gandhi's table, and I apologise for this, but if you go to that page of his statement, which is B41, under the table there's a footnote that refers to page 167 to 181 of DG1. Now, I can't see where that footnote comes from, and I can't find...
The footnote is in the first column, the financial year ending 2014 to 2015.
Right. Okay.
So it's very old accounts that are referred to in the exhibit.
There's a reference there to page 167 to 181. So what's that a reference to? DG1, I assume, is Mr. Gandhi's statement, but...
I anticipate, we'll check this as well, but I anticipate it showed the financial accounts for that year, and that may show us the year end.
Yeah.
So
Right.
we'll try to follow that through.
Thank you. Because that doesn't seem, the exhibits don't seem to be in the appeal bundle.
We'll check that and see if we can follow that up.
Thank you.
Mr. Watson, is Mr. Montague-Smith still not been able to join?
No, I'm back online. Sorry about that. The
Thanks.
system seems to allow the call to run for a certain amount of time, and then it just ends it. So I'm afraid this is going to be a periodic problem for me. I'll try and... it'll probably be more obvious when I'm making submissions.
While you're off the line, I just asked Mr. Macefield about a footnote under
Yes, I see.
Mr. Gandhi's table. Yeah, one, and it was just refers to the accounts. It appears that the accounts for 2014-15 may have formed part of the bundle of documents to which you referred in your statement. So that might give us a clue about what the financial year was.
Thank you.
Anyway,
I will check.
Good.
See what I can do.
Now back to you, Mr. Macefield.
I was going to move on, Your Honours, to grounds 3 and 4,
Yes.
the counterclaim by the bank, which was in respect of Amira's outstanding indebtedness. Now, at trial, the bank was claiming a total of just over $6.4 million and interest, made up from various sums due in relation to expired buyer's credits and Amira's overdraft facilities. And Amira did not dispute that it had received that money from the bank, nor did it suggest that it had ever repaid the money to the bank. Indeed, Amira has not repaid that money at any point to date and still has the benefit of that money. Instead, at trial, Amira mounted a defence to the bank's claim that the judge, rightly in our submission, described as a technical one. That one sees that at paragraph 180 of his judgment at F39. And the judge summarised that defence at paragraph 179 of his judgment, which we have at F39. The argument was as follows. Amira first said that an event of default under the facilities agreement was necessary in order that the sums become payable. It then said the only event of default on which the bank could rely was the one pleaded in its counterclaim, which related to a failure by Amira to pay the 26 February credits. Amira said that failure was caused by the bank's breach, and Amira said the bank could not rely on a failure caused by its own breach, and therefore the debt had not become payable. Now, we say that reasoning contains an important fallacy at step 1, and Amira's submission that the bank had to serve an event of default under the facilities in order for the debt to become payable was wrong, because it is in fact clear from the wording of the facilities agreement that the sums due under the facilities agreement were repayable at all times on demand. And without
Sorry, Mr. Macefield, doesn't that rather put it the other way around? Isn't the first question what was the basis of the bank's claim rather than what was the basis of Amira's defence? And the basis of the bank's claim was entirely related to the occurrence of an event of default which enlivened the obligation to pay, wasn't it?
With respect, not so, Your Honour. I'd like to show you, firstly, the way it was put by the bank below, because it was put by the bank in both its opening written submissions and in its closing submissions that the sums were payable on demand, and also by reference to the pleading.
Demand as a consequence. Sorry, but and I've seen that in the pleading too. But then when you view the allegation that the sums were payable on demand in the context of what follows, the proposition is that the bank was entitled to make demand because of the event of default. So that, in other words, there's that's. But I've seen your skeleton in which you say the way in which you put it, but and I've seen all the detail of that, so there's probably no point in going over it. But it just strikes me as the case seems squarely put on the event of default, and of course that was raised by the trial judge and counsel in the course of opening.
I'll come to that too. I'll come to that too, Your Honour. Can I? There are three things tied up there, if I can just unpack them. The first is whether this is a new point that's being run on appeal. And what I'll show Your Honour is that the point was run by reference to clauses 4.8 and 5.5, which are the ones that say that this was payable on demand. And it was said that these sums were payable on demand. That was the bank's primary submission by reference to those clauses. Those do not depend on any prior event of default. The second point is whether this was open to us on the pleadings. And I'll go through the pleading, Your Honour, and show Your Honour that it was open to the bank on the pleading. The way the bank had pleaded its case was on two alternative bases. One was that the sums were payable on demand and had not been paid when due. That then allowed the bank to serve a notice of default, which the bank did on the 6th of June. But the bank had also pleaded that there was a breach of contract before that point because of the repayments had not happened. And the bank had also pleaded that it then made valid demands before service of the notice of default on the 6th of June. And it was those pleas that were said to have given rise to a loss. And the third point is the concession point. And I'll also come to that, Your Honour, and explain why there was no such concession and why the court understood there wasn't a concession in that regard. And alternatively, if there was, why that shouldn't tie the court's hands in this jurisdiction to look at the contract, construe it properly, and see what obligations it contained. Can I start with the first point, the new point, that this was not, that the argument I'm advancing was not an argument that was advanced below. And if we can start by looking at the written submissions that the bank filed, which we have at A40, and it's paragraph 55, where there is an express reference, and it's said to be in any event, this is after the reference to staff on events of default, pursuant to clause 4.8 of the facilities agreement, Amira had irrevocably and unconditionally agreed to repay the buyer's credits on demand from the bank and to indemnify and hold the bank harmless from any loss or damage that may result. And clause 4.8 is then set out, and that's the one that provides that the borrower agrees irrevocably and unconditionally to reimburse and indemnify the bank on first demand made by facsimile and without contest in respect of any and all sums. So the point was taken in the written opening that clause 4.8.
Don't you need to read those paragraphs in their context? So that if you look at the paragraph that precedes paragraph 55, it starts, furthermore, there are other events of default on the part of Amira, and these are the events of default that I think ultimately came to be pleaded. And then it says, and then there's paragraph 55. In any event, there was an obligation to pay, and then 56, which is said to follow from 55, it says, in light of all of the above, the bank was entitled to call an event of default on 6 June 2018. Now that doesn't look to me like an argument that irrespective of default, there was an entitlement to make demand at any time. It looks to me as if this is an argument that there was a failure to pay, as a consequence of which there was an entitlement to call upon an event of default. That's how I would read that skeleton, I must say.
Your Honour, you're right, but the point is that it's a failure to pay that triggers the event of default, and it's the failure to pay the sums when due. So in order to establish an event of default, you have to show that the sum was due and payable in order to say the event of default was triggered, because otherwise you can't call the event of default. And what Amira was doing, what the bank was doing here, was by reference to clause 4.8, showing that the sum was due and payable, but had not been paid, which allowed it to call an event of default. So the sum is already due and payable because it's repayable on demand. And when demand was made, payment was not made. And one sees this as well in the course of the closing submissions of Mr. Francis on behalf of the bank, where on a number of occasions, Mr. Francis expressly submitted that the sums which the bank had advanced to Amira were repayable by Amira on demand. And he did so by reference to the clauses, in particular clause 4.8 that we've just seen set out here, and 5.5 in respect to the overdraft facility. Can I take the court to an example of that, which we have at page E151? And we've got there the submissions of Mr. Francis at page 170, and we can see that there are arguments about set-off and the like. And then at line 18, he says, the outstanding amounts claimed by the bank relate to amounts advanced by the overdraft facility and buyer's credits, which were repayable on demand. And then he says, if I could take you to the overdraft clause, that's clause 5.5 in the facilities agreement. And on page 50, 5.5, all drawings under the overdraft facility are repayable on the bank's demand, together with all interest and other charges accrued to the date of repayment. And we can come to look at that in clause 4.8 in a moment in the facilities agreement. And he says, so we think that makes a position.
Sorry, Mr. Maxwell, we're at E151. What page of the transcript is this?
Page 170, Your Honour, line 18.
Thank you.
He says, the outstanding amounts claimed by the bank relate to the amounts advanced by the overdraft facility and buyer's credits, which were repayable on demand. And then he goes to the overdrafts clause, clause 5.5 in the facilities agreement, which we've referred to in our skeleton we can look at, which provides, and Mr. Francis quotes from it, that all drawings under the overdraft facility are repayable on the bank's demand, together with all interest and other charges accrued. So, and he then says at 171 line 2, so we think that makes the position rather clear. Of course, I've already taken you to clause 4.8, which in turn says pretty much the same thing with respect to buyer's credits. So it's not the case that the argument that I'm seeking to advance on appeal was not advanced at trial. At trial, both in the written opening and in the course of oral closings, Mr. Francis, on part of the bank, relied on clauses 4.8 and 5.5 in the facilities agreement, both of which say that the sums were repayable on demand. And those are the clauses.
Sorry, neither in the written opening nor in the closing oral submissions is there reference to when the demand is said to have been made.
That was set out in the pleaded case, and that's what I'm coming to next, Your Honour.
Well, fine, but the pleaded case refers to letters, all of which seem to relate to allegations of demand, which, if not met, will result in an event of default. The event of default resulting in a demand ultimately being made on the 6th of June 2018.
It does both.
So there are really two different. Sorry, there are two quite distinct cases, aren't there? There's a case that, by reason of your breach, there was an event of default under clause 14.2, which enabled us to make demand, and we made demand by reason of the event of default. And that, when you read the pleading, seems to be the case that's being advanced. There's an entirely separate case, which would be based on clauses 4.8 in the case of the buyer's credit facility and 5.5 in the case of the overdraft, and that is, we could make demand whenever we like. Now, if those clauses were the source of the obligation to pay, you would expect to see them pleaded, and they're not, as best as I can see. Clauses 4.8 and 5.5, they're referred to by counsel, but they're not pleaded. And you would say, here was the unconditional demand to pay, and you didn't pay. But it's difficult. And anyway, I'm just letting you know the difficulty I'm having with the.
I understand, Your Honour. Your Honour, can I come to the pleading to have a look at that and just to walk through that? And before we do, can I just make this prefatory comment? When cases turn on questions of construction, nice pleading points by defendants are not generally regarded as being particularly meritorious. The courts tend to take the view, and one sees this in cases in the DIFCC as well, that the contract means what it says, and the court should give effect to what the contract says, and not to some other obligation that the parties did not agree to, and the parties aren't obliged to plead out arguments of construction in that particular claim or counterclaim. But if we turn up the pleading...
Sorry, the proposition that's put against you is that that might be true if the law with the substantive law with which we're dealing was either Australian or perhaps English law, but if the substantive law is the law of the DIFC, then subjective purpose of parties becomes much more relevant to the construction of a contract than would be the case in the jurisdictions with which you and I are most familiar.
Well, in the DIFCC case, in the DIFCC jurisdiction, there is a recent case. It's Vitalo and Vitalo and Atlas Mara, which we have in bundle G1, tab 5, G1116, where even in the context of the DIFCC, the Court of Appeal said that arguments of construction tend to turn on the express terms by the parties because prior conduct in negotiations and subsequent conduct is not terribly helpful for the court. One sees that at page G1119, the decision of the Court of Appeal in Vitale Atlas Mara, where the Court of Appeal noted, whilst the parties also sought to rely on pre-contract negotiations and post-contract conduct, the fact remains the form of words was negotiated between lawyers and no common intention could be found in the preceding exchanges beyond an ultimate agreement to the form of words used. Furthermore, post-contract conduct is often explicable on more than one basis, which does not help much in construing words used. We refer to this in a later context, but the focus must be on the words used in accordance with the principle set out in Article 49.2 of the contract law. And there was an earlier decision as well called Damak Park Towers and Yusuf Issa Ward, which we'll look at as well in the context of concessions, which is to similar effect. So we say actually in the DIFCC, a broadly similar approach can and should be taken to pleadings where points of construction arise. Now, if we look at the pleading itself here, it's a bundle A, starting at page A65. And the counterclaim is there set out, and we can see it starts with a general summary at paragraph 28, which says that in breach of contract, Amira has failed to comply with its obligations pursuant to the facilities agreement, including failing to pay amounts due and payable to the bank under the facilities agreement. Now, that's clearly a very broad introductory pleading, and it's certainly wide enough to include sums that were due and payable on demand under the facilities agreement. And when you look at paragraph 29, you can see that the claim against Mr. Chananar is also pleaded. The last sentence provides that in breach of contract, Mr. Chananar has failed to comply with its obligations under the facilities agreement and the personal guarantee, including failing to pay to the bank on demand amounts which Amira had not paid to the bank when due under the facilities agreement. So again, a broad pleading to cover the guarantee to pay sums which Amira has not paid when those sums were due under the facilities agreement. And then if we move on to A66, under the heading the facilities, we can see at paragraph 33 that it was pleaded that Amira was obliged to pay the bank 3 different amounts in respect of buyer's credits that matured on various dates. And the third one is the important one for present purposes, the $2.6 million maturing on 26th of February 2018. Because if we drop down to paragraph 36, it's pleaded that no payment was received from Amira in respect of that credit on 26th of February, and part of it remained outstanding. And then if we move forward to A68, we can see a heading, particulars of breach. Now this is before any event of default has taken place or been declared.
Well, just before you skip to A68, you see that in paragraph 37, the clauses of the facilities agreement that are presumably said to be relevant to the claim are set out, and there's a reference to clause 14 and clause 9. There's no reference to clauses 4.8 or 5.5, is there?
I accept that, Your Honour. I accept that. But of course, clause 14...
You would have thought, a reasonable reader would have thought, well, if the allegation is that the sums are repayable on demand whenever demand is made, you would expect to see those clauses pleaded, wouldn't you?
Your Honour, in an ideal world, I accept that reference would have been made to those clauses, but we'll see that a reasonable reader, including Amira, understood the bank's case to be put on an alternative basis, that sums were due, and alternatively, that there had been an event of default. Because we'll come to look at the bank's, at Amira's reply to this, sorry, Amira's defence to the counterclaim in a moment. Now, if we go forward to A68, particulars of breach. So, as I say, this is before there has been any declaration of event of default. At paragraph 40, it's pleaded specifically that in breach of contract, the first claimant did not pay the amounts due in respect to the 26th February credits on 26th of February or at all. So that's a pleading that the money was due on that maturity date and wasn't paid. It's not, and that's said to constitute a breach of contract.
Yes, but it's not an allegation that there was a demand.
No, not yet. We're coming.
Yeah,
we're coming on to that. That's the next heading down, and it's then said as well that the non, and this is para 41, that the non-payment on that date constituted an event of default. And then one has the pleading demand for payment and notice of an event of default. And at 42, it's pleaded specifically that the defendant demanded payment in respect of the 26th February buyer's credits and the other outstanding amounts on various occasions. And there are then three particular dates when demands were made, which are specifically pleaded: 27th February, 22nd of April, and the 1st of May 2018.
And then, if you go to those letters, isn't it the case that they all claim payment as a consequence of the occurrence of a default?
No, it's not. No, if one goes to those letters, because there's no event of default that's been declared, if one goes to the underlying letters, what one sees is that the bank was simply demanding at that point payment of the sums due. The first event of default that is declared is, I think, on the 6th of June, where the event, one sees that later on in the pleading.
Well, perhaps I put it this way. Wasn't it, and I've looked at the letters, I can't recall their exact terms now, but weren't they saying you owed us this, you were obliged to pay this money on the 26th of February, you didn't, as a result of which you've now got to pay it, and if you don't pay, there will be an event of default, and we'll claim all the amounts outstanding. Is that roughly right or not?
That is roughly right. And what that contains is two things. You've got to pay it, you haven't paid, and you've got to pay it. And it says, if you don't pay it within 3 business days, we'll go further and declare an event of default, as we're entitled to under the facilities. So you've got both the demand for payment, which in and of itself means that the sums need to be repaid. And then if you give notice, you have 3 days to try and remedy the default, following which you can declare an event of default. But both are being pleaded here. Both the demands, which in and of themselves make the sums payable, and then it's the failure to repay the sums after 3 business days that gives rise to the event of default. And one can see that clearly in the letter of 27th of May, which is pleaded at paragraph 50, Your Honour, because in that letter, Allen and Overy, my instructing solicitors, wrote to Taylor Wessing, making a final demand for payment and providing the claimant with 3 business days to do that, i.e. to pay by 30th of May, in accordance with clause 14.1a2. Now, we need to look at the facilities agreement, my lord, but what 14.1a2 provides is that if sums are due and have not been paid within 3 days of demand, then you can declare an event of default. And so this was the final demand, which in and of itself...
Where do we find that letter? Can you help me, Mr. Masefield? Where do we find that?
Let me ask my instructing solicitors whether...
I believe it's in... I hope it's the same one. Sorry, this is Mr. Montague-Smith. It's D4, yes. Document 36, page 71, I think.
Right. Let's see if I can find that. Six. Yes, that looks like it.
Yeah.
Yeah.
So, and if one looks at paragraph 2, the bank says that it considers the borrower has not provided any legitimate excuse to further delay payment of the amount. It's concerned to protect its position. And in accordance with clause 14(1)(a)(2) of the facilities agreement, the bank hereby provides the borrower with 3 business days from the date of this letter to pay the amount in full, i.e. by Wednesday the 30th of May 2018. So that's a final demand for payment.
What is the amount?
The amount is...
fine amount.
It's the outstanding amounts, which is in earlier correspondence, the sums claimed by way of the counterclaim. It's made up in the pleading from 2 figures effectively. It's the sums of money on the 26th of February buyer's credit, which is a tranche of about 1 million, given once you take into account other recoveries that the bank has made by way of set-off. And then there's the 4 million that was advanced by the bank by way of an overdraft facility to Amira, pursuant to the order of Mr. Justice Jeremy Cook. And when the bank advanced... Sorry
to interrupt, I hesitate. In fact, the amount is simply the residue that was left over of the 26th February buyer's credit, less the sums which had been netted off that were held in an account. So that the amount is 2.2 million. You see that from bundle D4, letter 33, page 61. So it's not quite accurate.
Well, that's what I thought, because otherwise paragraph 2 of the letter of 27 May doesn't make any sense. Because paragraph 2 says if you don't pay within 3 business days, then we'll call an event of default, which will have the effect of declaring all outstanding amounts immediately due and payable. So isn't it right, Mr. Masefield, that what the bank was saying is you've got to pay us the 2 million, and if you don't, then we'll call an event of default, in which case the entire 6.4 million will be payable. And if that's right, none of these letters would constitute a demand that would sustain your counterclaim for 6.4 million.
Your Honour, I'll come back to that, but it would at least sustain the demand for the lesser sum that was still due in respect of the 26th February buyer's credits.
Well, but only if you were running a case on that basis. And there's no suggestion in the case that you were running a case for only the 2 million. And that rather suggests that where in your pleading you refer to these letters as constituting the demand, they were steps on the path to a conclusion that there was an event of default which you declared on the 6th of June, and that there was in truth no alternative case to the effect that there was an amount payable on demand at any time.
Your Honour, if we go to A72, we have in our pleading the table which sets out the amounts that were sought to be recovered, broken down.
A72, yes.
And we can see that the sum on the overdraft facility was originally 1.6 million. And the 26th February buyer's credits, there was a further sum of 2.5 million, slightly over. And then some money had been recovered by way of cash set off. And then there was the advance of 4.1 million US dollars, which was paid by the bank by way of an advance on the overdraft facility. following the order of the court, and Amira was invited to agree alternative terms for repayment of that overdraft, because the default position under the facilities agreement is that sums on the overdraft are repayable on demand. That's clauses 5.5 and 5.6. But Amira did not propose any alternative mechanism for repayment of those sums. And so, as a result, it was stuck with the default position.
But that table, again, if you go to the prefatory words of paragraph 56, as at the event of default notice, the outstanding amounts were. So in other words, it all looks like a claim based on the proposition that we demanded payment of the buyer's credit. Well, you were due to pay the buyer's credit on the 26th of February. You didn't. We kept on asking you to pay it, threatening that if you didn't pay it, we would declare an event of default. You didn't pay it, so we declared an event of default. And these are the amounts that you owe us as at the event of default. It doesn't look like a case that we were entitled to claim all outstanding amounts at any time whenever we chose to do so. Does it?
Your Honour, I hear what Your Honour says, and the court should know that we have commenced, because this technical point, it was described by the judge as a technical pleading point, and he said it would be open to us to start fresh proceedings if we didn't succeed with the way it had been pleaded and put here, because the sums hadn't been repaid, he pointed out, they remained due and owing. We have followed that course. We have started separate proceedings. A new Part 8 claim has been commenced in the DIFCC, which at the moment has been stayed by the order of the court to await the outcome of the appeal. Now, if the court is against us on the way that it was pleaded originally and says that the counterclaim can't succeed on that basis, I'm not going to push the point too hard, because we have the benefit of that new further set of Part 8 proceedings, and in those pleadings we plead very clearly that the sums are repayable on demand, and that demands were made, and in the alternative that there was an event of default that we were entitled to declare, and the sums are still not being repaid. It's said against us by Mr. Montague-Smith that those separate proceedings would be an abusive process, and that we're somehow stopped from advancing that case. That's a matter for another day and for another court to rule on. We have to say, with the greatest respect to my learned friend, that seems to be a very extreme position, because the sums on any view remain outstanding and owing, and it would be extraordinary in our submission if the court was to find against us on a technical basis in relation to these first proceedings, and then say that was your one chance, and Amira is now entitled to hang on to the full 6 million. There is, we say, very little merit in that approach, but that's an argument for another day, because when you look at the authorities on abusive process, it's really only in extreme cases where the claimant is being wrongly vexed that such claims are disallowed. So I'm not going to labour the point before the Court of Appeal today, because we have the comfort of those second proceedings. But I would just make the point, so that everyone is clear, that this is, the judge in our submission was entirely right to say that this was a narrow defence, a technical point, and if we lose on it on the basis of the pleading, so be it. But we do say that it would be extraordinary if the result of that is that we are then forever and a day precluded from recovering these sums due by way of other proceedings. Your Honour.
Yes, well, I understand that, Mr. Maxwell.
Unless, subject to anything my solicitors want to say, if I could just use this opportunity to ask for, take instructions, just to see whether there's anything further they wanted me to say.
And I'll just ask my judicial colleagues if they have any questions of you.
Not at all, Your Excellency. No, I'm okay with that. Thank you.
I'm just waiting if the court will bear with me for a moment. If my instructing solicitors can let me know if there's anything further that they would like me to address on any of the grounds. I'm grateful, Your Honours. Those are my submissions by way of opening. We've happily managed to finish 8 minutes earlier than we'd anticipated under the timetable, so we can, I hope, take an early lunch and resume I think it's going to be 1:30 UAE time, 10:30 English time.
I'll just ask Mr. Montague-Smith if that timing is convenient to him. Are you worried about time, Mr. Montague-Smith, for your submissions?
Your Honour, I was a little worried about time, but it may be that you can move me along. I don't know whether or not you have any instructions for me as to what I do and don't need to focus on. I do have one observation, which is this, that there was a question as to when the year end was for Amira.
Yes.
And if Your Honours have a look at bundle D2, document 10, page 62.
So that was B2, was it?
Sorry, D2, bundle D2, document D2. 10.
D for Delta.
D2.
Yeah.
D for Delta, thank you, yes. I always forget those. D2, document 10, page 62. And you should see there at the front page of the financial statements, and indeed the second, it continues. This is for the year ended 2017, but it shows that the year ends for the Amira entity we're concerned with on the 31st.
So D210, I don't, is something entirely different. It's a bank statement.
Oh, I'm sorry. Yeah, you're absolutely right. D211, apologies.
D211.
So you'll see the first page of D211 is page 61, but if you go to the second, you'll see the financial statements, and then they continue over on to 63 as the.
So it seems to be a year ending 31st March 2017.
Yes. So that was just to clear up your question.
All right, thank you. So then the question that I might ask you, I suppose, is if the year ended in March of 2019, assuming the financial year stayed the same, why weren't accounts for that period produced in a trial in July 2019? That's a question you can come to after the break, if you like.
Understood. Yes, thank you.
Yes. And so would you like to come back at quarter past the hour, or are you content to come back at half past the hour?
If everyone's happy to come back at quarter past, it might just give a little bit more breathing space.
Is that convenient to everybody, including my judicial colleagues?
Yes, that's convenient.
Yes. All right. Well, there are different hours, so I won't nominate the hour, but we'll resume it. Whatever hour it is, we'll resume at quarter past it. All right. Thank you, everybody.
I'm grateful.
Thank you, Anna.
We'll see you shortly.
Mr. Montague-Smith, I've been able to confer with my judicial colleagues, and having had the benefit of your written argument on grounds 1, 3 and 4, we don't need further oral argument from you in relation to those grounds, so the only ground you need address in oral argument is ground 2.
I'm grateful, thank you, Your Honour. In which case I shall find my place in my notes. All right. Sorry, lost my place. Apologies, I had to reboot everything as I tried to get back online. So I'm there. Thank you. All right. So just not.
You are online. We see you. We hear you.
Yes, thank you. All right, so this is the ground that deals with the question of general damages, and Your Honours have heard about the circumstances of the breach. You'll be familiar with that by now. So we've got the 11th of February 2018 is the date of the irrevocable letter, and that's the promise that the bank made that when it received money into Amira's account from the customer, Kuwait Flour, then on instructions it would pay that on to AK Global, and then the money comes in 3 days later after that promise is made, but then it's not paid out. And then there's a bit of a delay, and then on the 24th of February, the bank said, well, there's going to be no extension of the buyer's credits that had pre-existed, and in particular the one that was due for repayment on the 26th of February. And so then the bank said, well, organise the payment on the due date, that being 2 days later, the 26th of February. Now, in his judgment in May of 2018, His Honour Judge Cook had already found that Amira had suffered damage to its reputation as a result of this. But the judge acknowledged that it would be very difficult to quantify. And the reference to that is at paragraph 31 of the May order and the reasons for it, and that's at bundle A, tab 12, page 134. I don't think we need to go to it, but what he said was the failure to honour the facility agreement by the bank resulted in loss of present and future business and risk of loss of further business with knock-on damages to reputation. All those matters will be hard to quantify. And so at trial, Amira's evidence was that the bank's failure to honour that obligation had had a devastating impact on its business. And in effect, its position was that the bank was announcing that Amira was not good for the money. It made that clear, it became clear to AK Global, which was Amira's biggest supplier. It became clear to Kuwait Flour, which was Amira's biggest customer. It also became clear, as we've seen, to another two companies, in particular the Seychelles company, which was one of the other biggest customers. And the bank, it emerged in trial, had in fact publicised the position to other banks by placing this information on a central repository, which was available to other banks. And there is, and I'll take you to it, there was also evidence that in effect this had become common knowledge, or would have become common knowledge in the market in which Amira operated. So what I was going to...
What was that? Are you going to take us to that evidence in due course?
Yes, and I don't want to overstate the evidence. That's what I say is the effect of the evidence, and I will take you to it. What I was going to do...
Well, just on the subject of the Seychelles company, is there any evidence that they knew of the bank's dishonour?
Not directly, but if I may, can I go through each of them
Yes,
and just explain what I say about each of the bits of evidence? So if I go straight to that, then perhaps hopefully at least some of the questions will be resolved. So the first place I wanted to show you was in the second witness statement of Mr. Shanana, which you'll find in bundle B. And if we go to tab 4, and it's page 32, I'd like to pick it up, paragraph 18 in particular, which is dealing with then the main, this simply identifies that the main supplier refuses then, as we know, to conduct any further business. And then at paragraph 20, Mr. Chanana says he's witnessed the loss of opportunity that the first claimants suffered, and then over the page, and this is particularly some evidence that was relied on by the bank at little a, reduced margin. He says, I've had various conversations with Kuwait Flour since February 2018. Kuwait Flour was on the verge of cancelling its contract with the first claimant. The first claimant expected to lose around $900,000. However, in order to keep our business with both Kuwait Flour and the second claimant, I arranged for Kuwait Flour to pay directly. Then B, in around June 2018, I was in talks with a potential buyer from Bangladesh. The transaction did not complete because the first claimant was unable to secure letters of credit. And then there was a loss in relation to that. And then C, the first claimant...
Sorry, Mr. Montague,
yes.
Before we leave Kuwait Flour, they continued as a customer of Amira, didn't they?
They did, yes.
Yes, so we can forget about them. And then in relation to the Bangladesh, well,
I'm not sure one can forget about them if we're talking about damage to reputation. If the suggestion is that simply because there was a continuing relationship with this party, that there was simply no damage to the reputation, I would suggest is not a fair conclusion to draw.
Well, except they agreed to pay more for the rice, didn't they?
Yes, I agree with that. They agreed, but there was no investigation of why they agreed to pay more for the rice. I think one can say, and I don't suggest, that it affected the terms on which they did business immediately after. I don't suggest that.
And in relation to Bangladesh, sorry, sorry, I interrupted you. No, please finish.
No, what I was just saying was that is not the beginning and the end. That's not the beginning and the end of the effect on the company's reputation.
And in relation to the Bangladesh company, that was the subject of a specific claim which His Honour rejected.
Correct. Yes, I accept that.
Yeah.
And then there is, and it's fair in rather general terms, at C, the first claimant's suppliers and customers and other trading partners have lost confidence in the first claimant's business and ability to meet contractual obligations. This loss of confidence is directly linked to the defendant's breach of the irrevocable letter and refusal to extend credit arrangements.
Well, that's just a bald assertion, isn't it? Is there any evidentiary value in that assertion at all?
Well, it is explained to some extent when one looks at Mr. Gandhi's evidence. But what I would say is, yes, there is evidential value in that. That was
what is it?
Well, it is to the effect of, and I accept in rather general terms, to the effect that there has been a detrimental impact in the market on Amira's reputation. And I accept that it's not particularized, and I accept it's in general terms, at least at that stage. It seems to me that faced with that, those are propositions which ought to be addressed to the witness in cross-examination. And if they're not, what you're faced with, sorry.
Wouldn't it be possible for the cross-examiner to take the view that in its current form, the evidence was of no value, and that he or she didn't want to give it value by cross-examining it to the point where it was of some significance? Yes.
Of course, the cross-examiner could take that view, and if, of course, that's your Honour's view, then we'll move on to the next bit. But in my submission, at the least, this is an assertion of facts being made by somebody with direct knowledge of the circumstances. And if your Honour feels that can simply be disregarded, then we'll move on. But in my submission,
no, I'm not suggesting it be completely disregarded, but I'm suggesting it would have carried a lot more weight if there had been some evidence of a drop in trade coinciding with the dishonour of the bank's dishonour, and the only evidence we've got of that is Mr. Gandhi's table.
Yes, I accept that. As to the figures, that's all we've got.
There's no explanation for failing to provide either management accounts or audited accounts for the period ending March 2019, is there?
Well, not on the face of the evidence in this case, but the way it's put, my learned friend, is, well, in certain circumstances, the court can draw adverse inferences, and that is right. There is authority as to the circumstances in which the court can draw adverse inferences. So what's being said is, well, because you didn't produce this evidence, we can infer that it wouldn't support the evidence that you have given. But that proposition is surrounded by law, and in particular in the Wisniewski case in the Court of Appeal in England. And it's never previously been suggested that there would be adverse inferences to be drawn, and certainly none was advanced at trial. But if you are going to make that proposition and take that position, you have to warn the other side that is the position that you're going to take. You have to make it very clear that you're going to draw X inference from Y fact, and give them an opportunity to meet that. So what happened at trial was you got the evidence of Mr. Gandhi, which you'll see at bundle page B41 in particular. And he sets out there what he said to be evidence that demonstrated the performance of the first claimant's business over the last 5 years. Now that was, and then he set out the table there, and he accepted that table was based on projections, but the source of it isn't necessarily, again, the beginning and end of the value of that evidence, because what he is saying is this represents the financial performance of the company, and he was never challenged on that.
Was there any exploration of what gross profit means?
No, there wasn't. I see your Honour's point in relation to that. I understand that. But what I'd say is that none of this was explored in cross-examination. It was never suggested that, as appears to be the point taken now, that these were unreliable figures. If it had been suggested that they were unreliable figures, then that would have been put to Mr. Gandhi in evidence. He would have had an opportunity to explain himself and why, in his view, these were figures which, as he put it in stark terms in paragraph 8, demonstrate the performance of the first claimant's business over the last 5 years. And as to the question of why wasn't it...
Well, sorry, just before we leave that, It seems that the only figures really of any relevance are in the last column, because the financial year 2018 would have ended in March 2018.
Yes.
Shortly after the dishonour.
Yes, correct.
And the last column is simply sales targets for 2019. It's not actually figures at all.
Well,
as I think emerged when you re-examined.
Yes, and I accept that that's what they're based on. But what he is saying at trial, at that point, is this demonstrates or demonstrates, he says, the performance of the first claimant's business. So yes, it's based on projections, but he's saying this reflects the performance. That's his evidence. Now, I accept there are many ways in which one might attack that.
Just again, his evidence is the performance for the 4 years. It's not performance in relation to the only relevant year. It's projections.
Well, I understand he's written projections into the table, but I think the point I'm trying to make is if one looks at how he introduces that table, what he says is the below table demonstrates the performance over the last 5 years.
But a projection doesn't demonstrate performance. The projection, that's true of the first 4 columns. It's not true of the fifth one, is it? The fifth one is simply a recording of the sales targets set by the sales team without explanation.
Well, but what he's presenting is that those figures are an accurate representation of the performance of the company. That's how I read his evidence. So he says, as I say, look, it's in 2 places, I would say. He said, as he introduces it, says these figures demonstrate the performance. Now he says they're based on projections, but he is saying in terms they demonstrate the performance. And then at the end, he's saying the diminution in the company's gross profit has been as a result of the defendant's breach. So, you may discount that evidence as being opinion evidence, but what he is saying is that the gross profit of the company has, in fact, as a matter of fact, fallen in that way.
But he's not saying that, because the only way in which there is a fall of profit is if you take the projections as actual. And so we don't have the profit figure for the year, so he can't say that there has been a diminution in profit.
Well, he might be able to say that these were based on projections, but they're accurate.
Well, he doesn't say that.
Well,
but he doesn't say that.
Right. Well, I think you take a different.
Does he?
Well, I disagree, I have to say, but I mean, I understand your honest point.
He doesn't say it in the witness. He doesn't say it in the witness statement, does he?
Well, what I'm saying is that that's my assessment of the thrust of his evidence. But I mean, I've made the point, and I won't labour it because I think we're going over the same ground. If Your Honour takes a different view, and it seems that Your Honour does, then I'll move on. But I think I've made at least tried to make the point that I was making, which was that yes, he's saying they're based on projections, but he's presenting them as actual figures, and therefore his evidence, the effect of his evidence, is that the projections are accurate, or they're the best information that he's got.
Well, he then goes on to say, as a trained accountant, I can attest that the diminution in the company's gross profit has been a result of the defendant's breach. Well, yes. Training in accountancy doesn't qualify you to say that, does it? I accept that. Yeah.
So I don't rely on it for that purpose.
Yeah.
But what if Your Honour was to accept the submission that I do make, then you would be able to accept that this is at least evidence of a sharp decline in sales, and sharp decline. So we can see a 50% reduction in revenue, approximately, and then approximately a reduction of about $23 million of gross profit, which fits in time with the breach, and so it's part of the evidence that we rely on to say that the consequences of the breach were very significant.
Whatever gross profit is.
Well, I understand Your Honour's point in relation to that, but at the very least, even if one just takes this as, even if one takes that point on board, one can see that gross profit declines very substantially, and revenue declines very substantially, and therefore the performance of the company has been very substantially damaged by some events, as between those 2 financial years.
Would it be reading too much into the judgment to perhaps conclude that the trial judge may have treated gross profit as if it was net profit, because in the end, having rejected the any guidance as to the quantification damage to reputation to be drawn from the drop in share price, all he's left with, it seems, is he says, well, all I've got left is Mr. Gandhi's 23 million. I'll discount that and arrive at 10, which would be understandable perhaps if it was a 23 million drop in net profit. But when you don't know what gross profit is, it's hard to see how you arrive at a capital sum of 10 million from that starting point, isn't it?
Well, one normally would assess the loss by reference to the gross profits, because the changes there wouldn't normally be expected to be changes in the overheads, for example, unless it's being said that there was downscaling of the company as a result of the breach, and therefore acts in effect another mitigation argument being made. It's the gross profit that matters, isn't it? Because that takes into account both the revenue and the cost of sales.
Well, whatever the components of gross profit are, we just don't know. That's the problem with this evidence. We're just,
gross profit
so vague and sketchy.
Well, I understand that the criticisms that are made. I think what's said against me is this just simply can't be relied upon. I accept that it could have been more effective if it had been supported by detail. But if, for example, it seems to me the bank's advocates wanted to say, well, we just, as you say, don't know what gross profit is in these circumstances, then that is something which could have been, and I say should have been, addressed to Mr. Gandhi. So one would normally see, for example, on a profit and loss account, a line which says gross profit, and one wouldn't normally look at that and say, well, we don't know what's included in that, we just don't know what's incorporated. Even except summary accounts.
Well, the gross profit would usually show what's contributed to revenue and what's been deducted from cost to arrive at gross profit. There would usually be line items. But is any light shed on this? You took us to a set of accounts just before the break. I think it was for the financial year 2016 and 17. Do they shed any light on what gross profit might mean?
Might do. Bear with me, sorry. I'm just trying to remember what the someone will tell me, no doubt, what the
yeah, it was D. I'll see if I've got a note.
It was D62, wasn't it?
D62. Which D? Is it
D262?
D262. Let's see.
So you'll see at D269.
Yeah.
The continuing operations show sales and cost of sales giving the gross profit. In terms of actually the line items involved in the, so that's as I had suggested would be.
And how does that compare to the figures in Mr. Gandhi's table?
So this would be for the year ends 2017 and 2016. I haven't done this exercise. So they do, yeah. So those are the same figures. Yeah. So for the year end March 2017, you've got 100. You see that the gross profit is 147,461. And if you go back to Mr. Gandhi, you see the sum there for gross profit is 147.46.
Right.
So and then it's the same for the previous year.
Right. And then
167,254 for the previous year, which is 16725.
Right.
I think those are the latest.
Yes.
And so the question comes, well, why aren't there any? Why didn't we produce these sorts of accounts at trial? And the answer which would have been given if there had been, and there's no evidence on this, but they don't exist, is the answer. And the answer, that's the answer which would have been given if there had been cross-examination on these points at trial. And so
what there must have been, surely there would have, it must have been management accounts, mustn't there?
I don't know what the position is in relation to the management accounts. I can't help you with that. I just don't know.
I mean, there would be a ledger. There'd be a company of this magnitude would have to maintain some ledgers in relation to costs and revenue, you would think.
Yes, I don't know in terms of the broader financial information which might be available. I simply don't know what the position is in relation to that. In relation to formal audited accounts, the position is that they just don't exist. So I can't help you any further in relation to the broader points. Sorry, Your Honour, I'm not sure whether I've still got everyone. Yeah. All right. So I think the point I'm trying to make is that yes, I accept that there are valid criticisms which might be made of the evidence which was advanced in support of this part of the claim. But the criticisms which are valid are ones which are reflected in the judgment of His Honour Justice Giles. And some of the criticisms that go beyond that in my submission are really points which, if they're going to be made, they need to be the claimant's witnesses need to be given an opportunity to answer them, and that we clearly have a disagreement as to quite how that table is being presented. In relation to gross profit, there's no, it seems to me, particular reason to understand those figures as meaning something different to the ordinary figures that would be provided, gross sales minus cost of sales. And that would ordinarily be the appropriate figure for the assessment of the losses arising out of those sorts of breaches. Now, as I say, I don't rely on Mr. Gandhi's evidence as to the cause of that. And he says he's a trained accountant, fine, but he wasn't there to give an expert opinion, and that's not his role. But it is part of the evidence that the judge was entitled to rely on in identifying what was the scale of the harm that was done to my client, to Amira, as a result of this breach. There was further evidence in relation to what the wider impact of this on the market. I just want to show you two very short bits in Mr. Gandhi's statement. If we go back to Bundle B and page 44 of that.
What paragraph you're referring to?
So it's paragraph, firstly, just 22, where he deals with the effect on the relationship with the second claimant, that's the supplier AK Global, and then 26 is the paragraph that I was referring to. So again, I don't want to overstate this evidence because I can understand some criticisms might be made of it. But what Mr. Gandhi is saying is that in the market in which we operate to each other, and after the contract ended with the second claimant, it is unlikely that the first claimant is going to be able to find another supplier who will contract on the same terms as the 30,000 ton contract with the second claimant. So he uses it to support the position that we're going to find difficulties in replacing the supplier on such good terms. But what he is saying, in effect, is that the information would have become common knowledge in the market in which Amira operates.
Mr. Smith,
So how can he?
yeah, sorry. Yeah, I was wondering if you're still online, Justice Martin.
Yes, I am. How can Mr. Gandhi say that? How can Mr. Gandhi say it was common knowledge in the marketplace?
Well, he doesn't go that far. What he says is that suppliers and customers talk to each other, and he can say that as a matter of fact. As a matter of fact, if it's right that they operate in a small physical space, which is the case in relation to these traders in Dubai, and they talk to each other about news in the market, that he can give you that information. Now, you can then draw the inference that that happened in this case, that therefore the information was disseminated. That's why I say the effect. I don't say that he says it in terms, I say the effect of that evidence. You can take it from that it was disseminated, the information was disseminated within the market to suppliers and customers.
Well, the information in the form of the bank's dishonour.
Yes, well, I take the point. The precise terms of what information was going to be circulated is difficult to say. But if we look at the way in which, and I'll take you to it in a moment, the way in which AK Global responded to this, and what AK Global took from these events, it's that sort of information that I say one can infer would have been disseminated within the market. Let me show you that now if it's helpful. So there was a letter from AK Global explaining why they had terminated their contract. And your honours will find that at bundle D, tab D4, and it's page 176 of D4. It's document 59, I think. And I'm going to have to zoom in to see it properly. But if you go to page 170, so you'll see this is a letter from AK Global explaining what the arrangements were previously, why they terminated the supply contract, and their explanation appears on page 176. And what they say is...
Letter of 12 March?
Sorry, 11th of July, I'm afraid. So it's D4.
Okay. Yes.
And I believe it's tab 59. No, it's 60. It's 60. Yeah, I'm afraid when I click on it, I get slightly different things, and I apologise. I'm struggling a bit with the
yes.
with the technology today. So it's
a letter of 11 July.
Correct. Yes.
Yeah.
So this is a letter from AK Global, and they're explaining this is why we terminated this contract. And if you go down to page 176, you'll see in the final two paragraphs what they're saying about it. So the revocation of the irrevocable letter caused us to have significant concerns about the future of Amira's business. The revocation became common knowledge in our industry and resulted in a breakdown of trust. We therefore required future payments against stock already shipped to be made directly to AK Global from KFM, that's Kuwait Flour, rather than through Amira's banking process. Due to the revocation of IDBI's irrevocable letter, we were worried that Amira would be closed down, and so once we had received payment for the shipment already made, we declined to continue future business with Amira. So none of this was challenged. It wasn't suggested that there was anything wrong about that. It's right that the individual who signed that letter wasn't proffered as a witness, but one can say that's really a question of the assessment of that evidence by the judge. And there was quite a lot of debate about the assessment of the evidence at trial. And repeatedly, counsel for the bank would say, well, there's no evidence of this or there's no evidence of that. And the judge will say, well, that's not quite right, is it? Because we've got evidence. The evidence is in this form or the evidence is in that form. And it's quite clear that the judge wasn't just discounting this evidence that was coming in this sort of form. And that's really a question for him.
How did this letter come in, Mr. Montague-Smith? Can you tell us? Was it just tendered, or
I think it was attached?
There was no witness.
There was no witness statement from the individual who wrote it. I think it was tendered as an exhibit to a witness statement, but I can check that for you.
Right. Thank you.
There was discussion about it, I think, in examination in chief. But I'm afraid I'm sorry. I'll have to just give you the chapter and verse on that in due course. But
sorry, Mr. Smith, this letter did not come during the course of events. I mean, when the bank refused to pay, but it comes during the trial, isn't it? So it's come in a very later stage.
It did come at a later stage.
It didn't come during the trial. Letter.
Yeah. It didn't.
No, it didn't come. I mean, during. Yeah, it's not during the event. I mean, when the bank failed to pay, it just come about, I would say, more than 1 year after the event.
Yes, correct. So I mean, if someone had wanted to make that point, if someone had wanted to say, well,
this seems like it's your client acquired this letter.
Well, yeah. If it is being said that the contents of this letter is false, or that my client took steps to procure it in a way which somehow affected its contents, then that is clearly something which would have needed to be needed to be put to my client. One can't make allegations implicit or otherwise, that there's been some sort of interference with the way in which this letter has been
cross-examining, you mean?
Yeah, exactly. It needs to be put in cross-examination. So if this was to be challenged, it would need to be said, and there was no suggestion, as far as I'm aware. There were some very serious allegations made by the bank in the course of the trial. At one stage, it was alleged that the subsidiary contracts under what we call the umbrella 30,000-ton contract were shams, and that was withdrawn pretty swiftly after it was made. But there was, as I'm aware, no suggestion that, for example, this letter had been procured in a way which influenced its contents. And so the judge was faced with this evidence and was entitled to take it on its face. And had that sort of suggestion been, if it was to be made, then it would have had to been somebody would have had to be cross-examined on it, and the suggestion would have had to be made so that they could answer it.
Well, the letter on its face is written within the 2 weeks prior to the trial to Mr. Gandhi,
yes,
who was giving evidence at the trial in relation to the damages.
Yes.
So isn't there an inference just from the face of the letter that it was requested by Mr. Gandhi to support the damages claim?
One might draw that inference, but what effect does that have on the way in which you approach the contents? Is it said then that the consequence of that is that it's not to be trusted because for one way or another my client has influenced the contents of that letter, not the production of that letter? One can infer that the production of that letter has somehow been procured, but the contents of the letter is a different question.
Yeah. Yes.
So I'd taken it slightly out of sequence. I was just going through the evidence of Mr. Gandhi. If we can go back to that, please, and I'll just show you one or two other points that I wanted to draw your honour's attention to. Firstly, on page B45, so this is still Mr. Gandhi's statement, paragraphs 29 to 30. He says, from in and around early March 2018, the first claimant met with a number of banks to seek alternative sources of funding. I first met with Commercial Bank of Dubai, who refused to provide us with the facility that we were seeking. Every bank that the first claimant has approached since March of last year has refused to provide the first claimant with alternative funding. It would appear that the banks are refusing to lend to the first claimant. And it says, I met with the banks. I was able to work out the estimates for setting up replacement facilities, and these are the estimates that will materialise. But what he's saying is that after the breach, they simply were just turned down by bank after bank after bank. Now, again, you might say, well, all right.
Well, Mr. The evidence doesn't say why there is a rejection for providing facility by the bank. He said we could not arrange facilities. It's not saying because of this incident, not because of the appellant. The evidence is not saying that clearly.
Well, I think I accept that he is not necessarily saying that, but that's not something that he would have direct knowledge of. He doesn't know what's in the mind of the banks, and nobody knows what's in the mind of the banks, and that's why it's perfectly appropriate to draw inferences from the facts that we do know to the conclusion that credit dried up for the claimant as a result of this breach. And that is a conclusion that one can piece together from the evidence that I'm showing, Your Honours.
That paragraph 31, he says Bank of Baroda,
correct,
did continue to provide finance.
He says that he does, but then he goes on at 35 onwards to say that the Bank of Baroda facilities, do you see that at paragraph 36, have been insufficient for Amira's business model. To my knowledge, the business has not recovered since the defendant's breach of the irrevocable letter and the withdrawal of credit facilities. So I accept that, but it's not enough. And again,
was there any cross-examination on this, do you know?
None. None of this was cross-examined. None of this was challenged.
Yes.
And then the other piece of this is that it emerged at trial, as I've mentioned, that the bank did publicise its assertion that Amira was in default to other banks. And it's just worth picking that up in the transcript, because we find it at bundle E, day 2, and it's page 74 of day 2. And in particular, so if you start at page 70, do your honours have that?
Almost.
I'm going to skip over my rather clumsy cross-examination, or my first attempt at the cross-examination, and go straight to make it look as if I was asking the question, the final question in the first place. But if we start at page 70 on line 24, what I was doing was...
You're talking about E70 or 70 of the transcript? 70 of the transcript.
70 of the transcript. We're on E74.
Right.
And
Thank you.
if you look down at line 24, just to explain, put this in context, I was putting there had previously been an assertion of a default made by the bank against Amira, and a list of threats that were made as to what would happen next. So I was taking the Mr. Kumar through that list and asking whether or not each of those steps had, in this case, been undertaken. So the first question you'll see at line 24, was the central bank and were the regulators informed of these breaches? Answer, no. Did the information, was it uploaded into the central repository of information on large credit accounts? I don't recall that, but it must have been done. And then we'll skip my clumsy questioning down to line 18. That information would have been publicly available, yes. Answer, no. It would have been available to the banks, would it not? Yes. So that would have affected Amira's ability to obtain credit, yes, from other banks. Answer, yes. And then over the page, same page of the bundle, but page 72, line 17, you would have told the Reserve Bank of India then, yes. So that evidence shows that the information was being provided by the bank's own admission to other banks, and that it would affect Amira's ability to obtain credit. And that was, as was explained by Mr. Gandhi, as was explained by Mr. Chanana, the credit was absolutely crucial to the way in which Amira's business was conducted. And it is worth mentioning, I know my learned friend says, well, none of this was deliberate, but it is worth mentioning that the bank's response to all of this was entirely, we say, glib, because when dealing with the question of the effect, the impact that this had on Amira's relationship with its supplier, the response we got was at page E72 of the bundle, page 64 of the of this day 2, and at line 7, the question was, so in response to this, so what you're saying is it's not your problem, that's your response. And the answer that comes back from Mr. Kumar, who's the head of this branch of the bank, is yes, it's not my problem. That's his position. But the effect of this is that it damaged Amira's reputation, and I think I would suggest that the evidence is perfectly open to the court to say that the evidence suggests that the fact of these defaults and the conclusions which the AK Global drew from it, that Amira was under threat, that it might not be around for very long, became common knowledge in the market in which it operated. It became common knowledge in the banking circles, the relevant banking circles, and it meant that Amira could not obtain the credit, which was the lifeblood of its commerce. And that in turn crippled its ability to generate sales.
If it was such common, sorry, Mr. Montague, if it was such common knowledge, it would have been, you would have thought, a relatively simple task to get somebody to come to court and say that. But the only one who has is AK Global, as best as I can see.
Well, yes, but I'm sorry. You have that evidence from AK Global that it was common knowledge. And so the question is, could we have provided more evidence? Could Amira have produced more evidence? No doubt it could have done. But that doesn't help you evaluate the evidence that you have, which is that was... Well,
except that AK Global clearly knew of the dishonour because they had to change their practices as a result of it. They say everybody else knew, but nobody else is actually called to say that they knew.
Well, all right, but then well, again, I mean, fine. That goes to the credit that's to be applied to this evidence. And the question then is, why was nobody else called? That's a cross-examination point. I can totally see that. You might well say to Mr. Gandhi, look, Mr. Gandhi, you told them what to write in that letter, didn't you? Yes. No, I didn't. Yes, I did. Whatever the answer was. You could have gone and got somebody else to come. Well, what's the answer to that question? Let's think about that realistically. Is Amira realistically going to go out into the market and say, oh, now we've got this trial, and I want you, my prospective customer or my actual customer, my prospective supplier or my actual supplier, to sit through 3 days of the bank saying things like, these arrangements are shams. You're just trying to conceal the real truth of your arrangements. One has to take a reasonable and realistic approach to this, I would suggest. Those would have been the sorts of submissions that I would be making in answer to that submission at trial if the point had been raised in cross-examination. But it never was.
Yes.
And it's hardly surprising, I say, that once this information at least gets around to banks, but as I say, to the broader market, that it will have a very significant impact on customer confidence. As AK Global put it, they lost trust. They became worried that Amira would not survive. And as I say, that had its own discrete impact in relation to OK Global, but it's indicative of the serious impact that these sorts of events can have on a trading party's reputation, because banks are generally credited with acting properly. So if a bank is saying this company is in serious default, most people are going to believe them. If a trader is deprived of credit as a result, it's wholly unsurprising that it's going to decimate their business, we say. And you have that evidence as to the fall in profits. Now, as I say, there are criticisms to be made of the quality of that evidence, and it's fair to say that the judge made some of those criticisms, but he also found that it was too much to say that there was no evidence at all on which the court could act, and he found that there had been some harm, substantial harm, to Amira's reputation, and indeed we would say that that had already been established. There had already been a decision by Sir Jeremy Cook in his reasons, as I referred to. But we also say it's perfectly open to the court when determining this sort of loss to look at evidence of harm which by itself might be insufficient to establish a claim for special damages. And we do see some of that reflected in a case called Nicholson and Knox. So if you're dealing with a claim for special damages, we say for general damages, we say, yes, there might be criticism of the evidence. Yes, you might say, well, all right, we don't have a precise, clear pathway to getting to a quantified claim of $23 million in damages that represents the loss that was suffered as a result of these events. But you nevertheless do have evidence which you can use and deploy of substantial harm to the reputation of a substantial trading party, which had caused substantial knock-on damages. And so when Your Honours directed after the last times, and I haven't already apologised for this, and I do so, I apologise for the events of the last hearing, but after that Your Honours directed that a schedule of submissions be provided, a schedule of evidence be provided, and that was provided from our side. But included in the evidence from the other side, from the bank, are a series of points that you might expect to see in cross-examination. And I don't propose to go through that schedule point by point, but just by way of examples, one of the points that's, the schedule appears at bundle F, tab 13, page 201, if you want to look at it. Yes. But one of the points that's made, for example, at paragraph 3, I'm just going to turn it up actually. Unfortunately, you've got to turn it sideways if you want to look at it, which rotates the entire bundle in my screen, but there we are. Paragraph 3 says, Amira's main client, Kuwait Flour, eventually was told of the bank's refusal to provide credit by Mr. Chanana, but did not believe it to be true. And so what you've got here is a spinning of the evidence, because actually if we go to Mr. Chanana's evidence, which is at bundle B4, B tab 4, page 30, paragraph 10. He says, well, they initially didn't believe it. Kuwait Flour questioned how a bank could not pay the monies out when it had agreed to do so. And that's precisely the point. Banks normally behave in a responsible way. They don't normally fail to pay out when there's a straightforward obligation on them to do so. So it causes third parties to doubt the creditworthiness of the trader, and the traders asserting their own position becomes a problem in and of itself, because they're taking up a position which isn't being believed. So again, there's a destruction of trust as a result of it, and that trust is obviously absolutely essential to a party that is working on tight margins and credit and dealing with cross-border trade in the way that this party was. And various of the other submissions that are made in that schedule, for example, at paragraph 7, is this point where it said, well, there were new contracts were entered into with Kuwait Flour. I've been over that, but effectively what it's saying is, well, because Kuwait Flour continued to trade, there was just no damage to that reputation. But I suggest that that's not a realistic conclusion, because as your Honours may have picked up, well, Amira had actually had to step out of those 17 transactions in order to allow those to go forwards. It had interfered. It had caused a major headache for everybody. It had held up the shipments, and it had, as I say, put doubts in everybody's mind about whether or not Amira was creditworthy and could be trusted as well. And again, this is a cross-examination point. None of this was put to Mr. Shanana or Mr. Gandhi. And then again, it's suggested that, well, because Amira at paragraph 8 found a replacement supply, there was simply no damage to its reputation with suppliers. And again, I say that's just simply a non sequitur. It's wholly contradicted by the evidence, including the evidence from AK Global. And again, it's just not open to the bank when there was no cross-examination on it. So there's a series of points like that in the schedule. And what I say is that ultimately the evidence that I've shown, Your Honours, was just never really challenged. In fact, it was never challenged at all. And the criticisms of the judge are there, but they are criticisms which he made, and in spite of those, he made the award that he did. And in any event, as we've seen, some damage is presumed if we apply the principles which are described in the Kapoor case. And that was the case that's dealing with the bouncing of a cheque. And we don't have to go back to that case. But the principle that is repeated in that, which comes from the Wilson case, is that it's so obviously injurious to the credit of the trader that he can recover without allegation of special damage, reasonable compensation for the injury to his credit. So the learned judge said he was familiar with those principles. He directed himself to that case. He directed himself to Article 11 of the Law of Damages and Remedies, and in particular to both Articles 11.1 and 11.3. And it's right that one has to show certainty of harm, but once that is established, then the amount of damages is at the discretion of the judge. And that I would suggest there can't really be any real dispute that he had enough material before him to say it is certain that, or in my mind I'm certain, or I'm sufficiently certain on balance of probabilities, that the reputation of Amira has suffered damage. As I say, that would be presumed in any event, but there was plenty of evidence on which he could make that assessment. And so the question comes down to, sorry.
Isn't the question for us, assuming that to be so, and as you say, it's presumed anyway, the question for us is whether, having regard to the well, paucity is too strong a word, but having regard to the economy with which the evidence was produced on this topic, whether the award of $10 million was within the range of sound discretionary judgment when so much more evidence could have been adduced but wasn't.
Well, I think that's...
Isn't it?
Yes.
Isn't that really the evidence?
Yes. So I think that's right. But to unpack that, there are two questions inside that. One is about the quality of the evidence, and the other is about what the evidence, if it's accepted, shows. And so if you're doubting the quality of the evidence, then one has to look at the way that it was addressed at trial, and what was put forward at trial, and the way it was addressed. And as I've said, if it's not challenged, its quality is not challenged at trial, by cross-examination in particular, then the judge is perfectly entitled to accept that evidence as being accurate. And then the question is, well, right, well, what's the content of that evidence? And that's what we've been going through. So it's right that there is a question as to the quality of the evidence, but it can't bite at both stages, if I can put it like that. It might say, I don't accept that the quality of the evidence of this piece of evidence is sufficient, and the judge just should never in his right mind have accepted it. Now, I would suggest that this court ought to be very, very careful about interfering with the exercise of that sort by a trial judge. And there's copious evidence as to, copious case law as to the approach that an appeal court should take. And ultimately, it's generally accepted that the assessment of evidence is the domain of the trial judge, not just because they can look the witnesses in the eyes, but they are just suffused with the case in a way which your Honours just can't be, because we can only show you fragments of the case and parts of what went before the court. So in relation to that, I say, A, it's just not open to the bank to make the sorts of points that it's making because they were never put to the witnesses, and B, in any event, it's really up to the trial judge to take a view as to that evidence and take a view on those sorts of issues. Then the next question is,
sorry, but if the points weren't put to the witnesses, whether we were there or not wouldn't make any difference, would it? Because there was simply no opportunity to test the witnesses' response to the propositions. If you dropped out, Mr. Montague,
no, I'm still here. I was worried for a moment, but I'm here. I'm here for now.
Good. All right. Yes.
But if you go down that line, then your question is, well, if you accept my first argument, then there's no need to go down and look at my second argument. I totally accept that. If I'm right that it wasn't put to the witnesses and it should have been, yes, your Honours can take a view as to whether or not things ought to have been put to witnesses or not, or didn't need to be put to witnesses. This court can do that. But if I'm right that those sorts of challenges should have been made, then you're absolutely correct. We don't have to get to my second point, but we don't get there because the points just fall away. They can't be advanced now. But if I'm not right about that, if it's said, well, no, actually, we're entitled to make an observations about the quality of the evidence now, even though they weren't advanced at trial, they didn't need to be, or the consequences that we can still raise them now, then I say effectively what you're being asked to do is second guess the judge's own assessment of the evidence with which he was faced. And that, I say, you should be extremely reluctant to do if you get to that stage.
Yes.
And what I say is that a similar approach should be taken when you're dealing with assessment of damages. That is fundamentally the domain of the trial judge. And so if you're dealing with an evaluative judgment, which is based on multiple factors, there has to be some manifest error of principle for the Court of Appeal to interfere, or, which amounts to the same thing, it has to be shown that the decision is outside the bounds within which reasonable disagreement is possible. Now, why does that amount to the same thing? Because it has to be so extreme that you have to be in a position to infer that there just must have been an error of principle in the way in which the judge approached his assessment. And there are multiple cases, we've cited them, which deal with these, whether you count it as an exercise of discretion, whether you call it a decision on the facts, or whether you call it an evaluative decision. It doesn't much matter. The test is the same. The evaluative point is the one that's raised in the way it's addressed in the Karafi appeal. And it has to be outside the bounds within which reasonable disagreement is possible. This judge was perfectly aware of what his task was. He was entitled to look at the evidence of actual harm to determine the scale of the damage which had been done. In other words, my primary position is that an award of general damages is not just an arbitrary tariff that's applied. You bounce a check, we give you a fine. You bounce a check, we give you a fine. In order to determine the level of the award, we say, the court is obviously right to try to get a sense both of the value of the reputation and the extent of the harm that's been done to it. And the primary complaint against this, it was put in various ways in the skeleton arguments, but ultimately it comes down to this, just simply that the judge awarded too much. And as a broad proposition, that is something that the court should be very reluctant, very slow to accept. And just dealing with also the quality of the evidence, it comes back to some extent, because it's important to remember why, in some cases, this presumption has been explained to exist. So, for example, in the Jamil case, where the House of Lords confirmed, that you can find that at G1, tab 22.
Yes.
And if you go to page, I think it's 324, I've got it. Yeah. At the foot of the page, this is not dealing with a trader situation. This is dealing with a more general kind of defamation action. It seems to me, do you see at the bottom of the page?
Sorry, what page are you on again? Sorry, Mr. Montague-Smith, what page are you on?
G324.
Right, thank you.
And at the foot of the page, paragraph 121.
Yes.
It seems to me plain beyond argument that reputation is of importance to corporations. Proof of actual damage caused by the publication of defamatory material would, in most cases, need to await them next month's financial figures, but the figures would likely to be inconclusive. Causation problems would usually be insuperable. Who is to say why receipts are down, or why advertising has become more difficult or less effective? Everyone knows that fluctuations happen. Who is to say, if the figures are not down, whether they would have been higher if the libel had not been published? How can a company about which some libel damaging its reputation has been published ever obtain an interlocutory injunction if proof of actual damage is to become the gist of the action? So that is the context in which these sorts of presumptions have been devised, because it's always going to be difficult to provide a comprehensive route map to explain precisely why X contract was lost or wasn't gained as a result of this sort of breach. Now, in that case, the claimant had suffered no loss at all because it was not a trading party. You can see that at page 304 at paragraph 11. It wasn't actually trading, it was a holding company. So the issue under this head is whether a trading company which itself conducts no business, but which has a trading reputation, should be entitled to recover general damages. And nevertheless, it was entitled to general damages, and it's in that context that Lord Bingham said at paragraph 27, which is on page 309, no, it's not. Paragraph 27 is on page 307.
Yes.
That where a trading corporation has suffered no actual financial loss, any damages awarded should be kept strictly within modest bounds. Now, I'm not suggesting that the award should be outrageous, and that if you accept that the award is outrageous, that it can be maintained. But what I'm saying is that one has to understand the context in which each of these assertions or statements is made before you leap to the conclusion that there's no such thing as a general damages award for more than $500,000. Now, to support that proposition, my learned friend relies on a number of decisions, and these, he says, show that damages should be kept, as he puts it, well below £500,000, or in his submissions, somewhere between $330,000 and $400, I think he said $50,000. And in truth, each of these cases relies or turns on its own facts, and there are various factors which we say you can look to get some sort of grip on the level of damages which ought to be awarded. And my own friend disparages and says it's misconceived our attempts to connect the sums which are awarded with the values of the facilities that are offered. He says there's no logical link between the damage that's done and the value of the facility. Well, we say there is a logical link because it gives the court at least some sense of the value of the claimant's credit reputation. So a person to whom a bank is willing to lend $100 will have a lesser credit reputation than a person to whom a bank is willing to lend $10 million, which was the total agreed credit limit in this case. My learned friend says, oh, well, dishonoring a smaller check might be worse because it implies that there's even less credit available. But that is not with respect to realistic submission, because a check for, take $100, a check for $100, which is dishonored, is liable to be understood to be a mistake. If it got around the market that a check for $100 had bounced, is that really going to have the kind of impact when my client goes out in the market and says that was just an error, or the bank should have paid out on that check for $100, as an obligation that isn't honoured to provide funding of something much more substantial of $10 million? That is of a different order. So where you have an abrupt failure to provide that level of credit, it designates, we say, a real and serious dispute between the bank and the trader, not something that can be written off as a mistake. And then it just comes down to the question of the bank's word against the trader's word in the market. We do also say that you can look at the value of the trading organization itself. And so in the Kapora Raw case, in that case, the claimant was awarded a sum of £5,500, which was actually more than its annual income. And in that case as well, there was suggestion there, we say, that it is permissible to use the size of the facility, in that case a check, as a yardstick for the damages. And I'll just show you that, if I may. It's at G1 tab 17.
Yes.
And it's page 232 of the bundle. And they're under the heading generally. So dealing with general damages, Lord Justice Evans, as he then was, said the above conclusions mean that I would dismiss both the appeal and the cross appeal and would uphold the Master's award of general damages of £5,550. He said that it was somewhat coincidental that this was £1,000 more than the amount of the cheque, although I think he meant by this that the appropriate sum by way of general damages could be calculated in that way in the circumstances of this case. Now, that's not wholly clear, but what I say you can take from that is that Lord Justice Evans is interpreting the Master as saying, well, it's somewhat coincidental. In other words, it's not a complete coincidence. There's some relationship between the value of the facility on the one hand and the general damages on the other. As I've said, we say that the claimant's financial position is also relevant. It helps to inform the value of the reputation which is being damaged. And it also helps the court to understand the extent of the damage that is done. So we say that the turnover and the value are, as a matter of logic, legitimate reference points for the claim. My learned friend says, on the logic point, he says, well, larger companies ought to be more robust. So the bigger your turnover, the less harm you're going to suffer. But obviously that's not a general rule. Some will be, and he takes the example of McDonald's. Of course, McDonald's will be able to absorb these sorts of knocks, but a trader is in a very specific and vulnerable position. It relies on the credit as its lifeblood. So it may have a very good reputation, which is based on a relatively fragile credit position behind the scenes, which was ultimately the case here. And the other point that we make is that in the Davidson case, which you'll find at G1 tab 14, page 201, if you go down to page 208, lost the relevant passage. I'll just find it. Yes, so it's the final paragraph on page G208, about 3 lines from the bottom. He says of the award, it must be sufficient to mark beyond a shadow of a doubt the complete lack of justification for making the aspersion which was made by this means on the plaintiff's credit. So it is a legitimate part of the function of the award to announce that the breach was totally unjustified. And here, as we've seen, there was no good justification at all. So what we say is it's quite obvious that the financial value of the awards in these cases is lower. But here, we're dealing with a company with a significantly larger turnover than anything that was being considered. So we're dealing with annual gross profit of around $40 million in the year prior. So that's not based on the projections. The facility was substantial, it's $10 million. We're not dealing with a man who's got a total turnover of less than $5,000 but is still awarded more than that. We're not asking the court to give some proportion of the total value of the company, which is, nor are we asking, nor are we dealing in this case with transactions which have much to do with the ones that are considered in the cases that are relied on. They're often concerned with checks for a few pounds or a few hundred of pounds. And again, although the evidence was, I accept, in some respects given in a general and unparticularized way, I say it was, when you look at it in the round, unequivocal and unchallenged. The market was aware, trading partners were aware, they'd lost trust, they'd refused to deal further, banks were aware, and only one could be persuaded to extend credit, that was the Bank of Baroda. But the loss of credit to a company in Amira's position was poison. And I do say that you can take it that trading collapsed. So on that basis, I say that this court should be very reluctant to interfere with the finding that's been made, with the evaluation that's been made. We do say it's relevant that the DIFC court takes a different approach to damages than in England. This is not an English court, and this sort of case has not come before this court previously. That's not an unusual situation to be in this court. We referred in particular in our submissions to the fact that this court is in a position to award multiple damages. Now, that is not, and I make this absolutely clear, not because I am claiming multiple damages or my client is claiming multiple damages in this case, but because we say that it reflects a fundamentally different approach to the approach to damages in England. So my learned friend goes through the history of libel damages and said, well, those had to be reined in by judges in England. But reining in damages is not, we would say, obviously a feature of a system like the DIFC courts, DIFC law, which permits the award of multiple damages, which is offensive to the public policy of the common law. So we do say you can take that into account as understanding difference. We also say it is dangerous simply to import cases on the English law of defamation. Defamation is treated very differently in the UAE. So the point of these, in fact it's a criminal offence in the UAE. The point of these particular cases is that traders are particularly vulnerable to damage to their credit reputation, and they suffer harm which is very, very difficult to quantify, very, very difficult to establish to the level that might be required to establish a claim for special damages. So the bottom line of this judgment, which I would ask this court to support, is woe betide a bank which behaves in this way. We say that would to reduce these damages to something in the order of 30,000 or $500,000 even of US dollars would entirely let the bank off the hook for wreaking what we say there is evidence of, this devastation on Amira, and it wouldn't come close to compensating Amira for its true loss. ultimately the judge heard the evidence. He had the benefit of hearing from the witnesses, and he had the benefit of hearing all of the evidence over 3 days of the trial. He was the fact finder. He directed himself properly, and he said in terms that he was quite familiar with the corpora, the principles that one sees being applied in corpora. So I say that there is no proper basis for this court to interfere with that, and it should resist the temptation to do so. That's all I had to say on ground 2, Your Honour. I'm sorry, I think you're still on mute.
So I keep on getting that wrong, Mr. Montague-Smith. Thank you for pointing that out. I'm just wondering if do either of my judicial colleagues have any questions for Mr. Montague-Smith?
No, I don't have one.
No,
thank you.
All right. No, Mr. Macefield, reply.
May it please you, Your Honours. Mr. Montague-Smith said that in the present case it was very, very difficult to establish this type of loss, where a trading company has had its reputation devastated and has suffered a dramatic decline in sales. The answer to that, Your Honours, is the management accounts. Amira was contractually obliged to produce management accounts. They were ordered to disclose management accounts. They didn't do either of those things. And Mr. Montague-Smith very fairly said that he could provide no explanation to the court as to why that was not done. And we said that management accounts would be the obvious data which would be available and could have been provided to the court if Amira wanted to show that there had been the so-called devastating decline in trade for which it now contends. It didn't provide those accounts, and it didn't provide any good explanation for its failure to do so. Instead, what Amira did was to put forward in Mr. Gandhi's witness statement the short table that we have looked at, which included the figure in the last column based on projections. Now, in re-examination of Mr. Gandhi, it's a bundle E54, we have the only explanation from the witnesses as to what those figures were based on. And it's, if we turn up E54, page 212, on day 1 of the transcript, we can see that in re-examination, Mr. Montague-Smith asked Mr. Gandhi some questions about the final column has some projections in it. We see that at line 19. Mr. Gandhi said yes. It was said you haven't attached any documents to the back of this. So he was being cross-examined about materials to back it up. What were those projections based on? Mr. Gandhi says yes. Mr. Montague repeats the question, what were they based on? How did you arrive at those projections? And we say over the page 213, line 2, he says it was based on our sales team's target. So not even strong projections, these are target figures, sales targets, to which Mr. Montague-Smith says, I see, and then the answer, they will give us some information, they're planning this much orders. So based on that, we prepare the sales data projections. And we say that is very unsatisfactory evidence when the management
Sorry, Mr. Macefield, to interrupt, but because Mr. Montague-Smith's point in relation to all of this is that in an adversarial process such as the trial that was conducted here, if you want to put to the court that the evidence is unsatisfactory, you have the obligation to first put that to the witness, and you didn't do so. So that, for example, Mr. Gandhi wasn't asked why the management accounts weren't produced, and he wasn't challenged on the proposition that the table which he produces accurately depicts the financial performance of the company. Now, isn't there, and of course the judge was critical of counsel for the bank below for non-compliance with the rule in Brown and Dunn, but isn't there an obligation in a party to adversarial litigation to put those propositions before the court for evaluation?
Well, you are obliged to cross-examine, and there was some cross-examination on these figures because Mr. Gandhi was asked whether this was actually based on any documents, and it was because that's what Mr. Montague-Smith is picking up on, the fact that he had been asked in cross-examination whether there were any documents attached to support these, and the answer came back no. So the question had been put, and the bank was entitled to move on at that point. It was Your Honour's point in during Mr. Montague-Smith's submissions, where Your Honour said that, of course, the bank is entitled, if it regards the witness evidence as unsatisfactory, to move on once it's established the unsatisfactory nature of it. We had done. These were only other projections. They weren't backed up, the witness confirmed, by any documents that had been disclosed. And Mr. Montague-Smith, in re-examination, we say, if anything, further undermined his client's case, because it showed that it wasn't even based on hard sales projections. This was targets produced by the team. And we are therefore in a position where we're entitled to say that this was evidence that was very, very thin. And the judge took that view below as well. He was highly critical of this evidence.
But if you're going to rely, if you're going to rely as you do upon non-disclosure of the management accounts in breach of a court order, don't you need to either give notice of that to the party or at least put it to the relevant witness, who I assume would have been Mr. Gandhi? And that was, neither of those things were done, were they?
Your Honour, I'm afraid I don't know, because I didn't conduct the case below. I don't know to what extent there were submissions and there was a dialogue with the court beforehand about the failure to produce this disclosure. But we were entitled to make submissions based on the material that was produced before the court, and to say it was extremely thin. And the court was entitled to take that into account, and the court did so. It was not at all satisfied by the projections that Mr. Gandhi refers to. And we'll see that in the court's judgment below, because the court notes concerns about the table that Mr. Gandhi had produced. I'm just looking for the paragraph. I'm sorry, I'll come back to that and provide and give your lordships a reference to that. But he notes that these were in fact sales targets. It's paragraph 162 in the judgment, which I think is around F.
Nevertheless, he was prepared to take the table as the starting point for his quantification of damages, wasn't he? And one infers, as Mr. Montague-Smith asked us to, that he did that because of the other unchallenged evidence expressed in very general and sweeping terms, but nevertheless unchallenged, about the impact upon the company's trade.
But there were specific challenges made to that evidence, because we went through the various specific losses that were identified, the loss of the Bangladeshi customer, the soybean material, and the loss of the Seychelles customer, and beyond that, it was wholly unsupported.
We'll just deal with the Bangladesh customer. That was Mr. Gandhi's evidence. Nobody challenged Mr. Gandhi and said, how do you know that it was, on what basis do you estimate that the Seychelles customer discontinued trading with us because of the bank's actions? And nobody challenged Mr. Chananar's very general assertions that the impact of the bank's actions on the company was devastating. Just completely let you go through to the keeper, weren't they?
No, my lord, we don't accept that, because Mr. Chananar...
Yeah, can you take us where it was challenged?
Sorry, let's take that in stages. So Mr. Gandhi's evidence on the Seychelles company was the highest he put it in his witness statement, is that there was a probable link. He said, I'm aware this probably was as a result of reputational damage Amira has suffered. And the judge at 165 and 166 of his judgment notes that and says that the only awareness that Mr. Gandhi could put forward was that it was probably as a result of reputational damage. And he then says Mr. Chananar's assertion of loss of confidence suppliers and customers was not backed up or further explained. And then the judge notes that, in fact, on the contrary, the evidence suggested that there hadn't been such a bad impact on Amira's trading reputation because it did contract with TI Agro and Impulse and SR Agro. It's true for a higher price, as the judge says, but in fact reselling to Kuwait Flour also for a higher price. And he said
I think we're across, Mr. Maxwell, I think we're at cross purposes. What I was asking was whether there had been any challenge to the witnesses. And Mr. Gandhi was not asked any questions about his assertion with respect to the Seychelles company, was he?
Your Honour, I can't answer that question directly. I would need to look.
Well, I don't think it was, and I don't think Mr. Chananar was asked any questions about his general assertions of devastating consequences. So the point, Mr. Or was he? If he was, you better take me to it, because
He was asked about the Bangladeshi buyer. We have that.
Mr. Chananar was, yes. But that was in, yeah. Sorry, the Seychelles. Yeah, but that was in the context of the specific claim for lost profit on the Bangladesh deal. But yeah. Mr. Chananar made general assertions about the impact of the bank's conduct. He wasn't challenged on those, was he?
No, Your Honour, because the bank took the view, rather as Your Honour had indicated, that those general assertions are general assertions. You don't need to cross-examine on every point. There's the rule in Brown and Dunn, but it's not to be applied as a trap for the unwary. You only, while you have to put your case, you don't have to do so in every single detail in the course of your cross-examination. You're entitled to take the view that the evidence is so thin and so inadequate that you can make submissions on it and it can address the court and say that there was unsatisfactory evidence. And that is what the bank said. It said in relation to the reputational damage that it was deeply unsatisfactory given the failure to produce any management accounts and given these sort of generalized statements that really were not backed up by any detail. These were.
Did it say that to the trial judge, or is it only saying it to this court?
No, that was, as I recollect, that was part of Mr. Yassine Francis's submissions on behalf of the bank at first instance in relation to the reputational damage and saying why this claim had not been proven.
And we'd find that in the transcript of the oral submissions, would we?
Yes, yeah, in the closing submissions.
Yes, all right.
Your Honour, Mr. Montague-Smith went to the letter from AK Global, dated the 11th of July 2019. Now, as the court has observed, that came a long time after the event. It's the document at D4176. And there was some discussion about how that letter had come to be obtained just 2 weeks before the trial, which the judge picks up in his judgment. He refers to this at paragraphs 77 to 79 of the judgment. And at 78, the judge notes the letter was addressed to Mr. Gandhi. From its date, Amira probably asked AK Global to write it in order to use it in these proceedings. Mr. Gandhi and Mr. Chananar were obvious targets if it was to be suggested they had prevailed on AK Global to write in more favourable terms than warranted. Mr. Chananar gave some rather obscure evidence that the letter came when Mr. Gandhi reached out to AK Global and asked them to start business again. And the judge then said neither he nor Mr. Gandhi was asked any more about the origins of the letter. So there was some evidence about the origins of the letter. And I accept it wasn't suggested that they had asked AK Global to provide a dishonest account, but it does seem that they had reached out to AK Global 2 weeks before the trial to put forward the letter. Now, what the letter actually says, when one looks at it, in particular the second page at D4176, is that AK Global had to make direct payments to Kuwait Flour and started doing so, and that subsequently it refused to supply. Now, both of those heads of loss have led to claims that Amira has pressed separately against the bank. So the direct payments resulted in a loss to Amira, which the judge quantified at $303,000. The refusal to supply was the subject of the reduced margin claim, which the judge assessed at some 2.2 million US dollars. So we say that those particular heads of loss are already addressed, and the impact on Amira's business is already dealt with by the awards that were made in respect of that. And beyond that, there comes a point in time, as I said in my submissions, where you have the bank's breach back in February 2018, but you can't start laying all future losses that Amira suffers at the bank's door.
But Mr. Masefield, sorry, Mr. Masefield, the part of the letter to which Mr. Montague-Smith took us and upon which he placed considerable reliance was the portion on the second page in which the author says that the bank's dishonour became well known within the market. Now, accepting that there is an inference that the letter was requested for the purpose of the trial, if you want to put the proposition that that portion of the letter was requested by the plaintiff in order to substantiate its claim for damages, you'd have to put that to the witness, wouldn't you?
You would. I don't seek to attack that as an improper statement. I accept that the revocation became common knowledge in the industry because I'm not in a position to say anything to the contrary. That wasn't as a result of the bank publicising it. It was as a result of dissemination within the industry. But the question... Right,
so you accept that there is evidence that should be accepted, that it became common knowledge within the industry that the bank had refused credit to Amira?
I accept there was some evidence that it had become disseminated. There is a question of the weight to be attached to this, which the court can consider and the judge could consider in the circumstances in which this letter was written. It's a statement of opinion rather than personal knowledge, and it is being put forward late in the day, very late in the day, just before the trial. But I accept, we don't say there is no evidence of some dissemination of the bank's refusal to supply, but one then has to see what impact that has, if any, on Amira's profit margin and what the evidence goes to on that. Now, so far as AK Global is concerned, we say that is adequately addressed by the other two heads of loss. There's also then the question about alternative credit and the suggestion that Amira had difficulties obtaining alternative credit. Now, in relation to that, it's right to say that there was no cross-examination because Amira had said on day one of the trial that it was not advancing any claim in respect of the difficulties of obtaining alternative credit. One sees that, Your Honour, at page E23 of the transcript, but page that 89.
Sorry, that was a claim for special damage, wasn't it?
It was, exactly so. And at page E23...
The claim that's now being put is that its reputation was damaged because it had difficulty, because Amira told other banks that it had refused credit. I'm sorry, IDBI told, your client told other banks that it had refused credit to Amira. Amira had difficulty obtaining finance from other suppliers, and that affected its capacity to trade. Now, that was a if you like, an aspect of the damage to reputation, not put as special damages. So that aspect of the claim wasn't abandoned, was it?
Well, that's the way that it's put now, but that's not how it was pleaded and proved. And the judge was also very critical of the evidence in relation to the difficulties of obtaining alternative finance, not least because it's clear that Amira did in fact manage to obtain alternative credit from the Bank of Baroda. And one can see, for example, at paragraph 149 of the judge's judgment, at page F32, that the judge says, paragraph 149, it is said that Amira could not obtain letters of credit. This is the fourth line down in that paragraph. But while Mr. Gander spoke of inability to obtain alternative sources of funding, there is no more direct evidence of efforts to obtain letters of credit in the relatively small amounts involved, or that the failure in those efforts was because of the bank's default under the irrevocable letter. And so the judge was critical of the evidence in relation to that. And he repeats that criticism at paragraph 166 of the judgment, because he says in the last four lines of that paragraph, as noted earlier in these reasons, refusal of other banks to provide alternative funding is not necessarily due to the bank's breach of the obligations, as distinct, for example, from the bank's more general refusal of further credit facilities. So the judge said that in relation to the supposed difficulties with alternative credit, the evidence of causal link on that was deeply unsatisfactory. And the way that Amira had put its claim, Your Honour, you're right, it was a claim for specific damages. That was pleaded out in Schedule 1 to the reply that we looked at earlier today, and that claim was quantified at $400,000 US, additional costs of obtaining alternative funding. It wasn't put any higher than that, and we say it is a huge leap from that and the claim in that sort of amount to then say that there is a much larger claim for damage to credit reputation. Mr. Montague-Smith says that he could rely on the presumed damage of harm to reputation. And the cases, of course, show that where a bank wrongfully dishonors a check, there is a presumption of some harm. But the cases also show you cannot use that presumption as a springboard to claim specific damages for loss of trading. One sees exactly that in the decision of the Court of Appeal in Corparolaw itself. There was a claim for general damages, which was allowed in the sum of £5,000, but the wider claim for special loss of Nigerian contracts, which was for £60,000, was rejected, both by the judge at first instance and by the Court of Appeal. The point being that if you do not plead and prove your specific loss, you can only claim modest general damages that aren't excessive but are temperate and reasonable. You can't use the presumption to springboard to a wider claim and do away with your need to prove that specific loss. And in particular, in the Corparolaw decision, which we didn't go to this morning, but Mr. Montague-Smith took the court to, we have that at G1, page 232 is the relevant page I want to go to. This was at the end of the section where the Court of Appeal is dealing with the claim for special damage and rejecting it. The court observes at G1 232 at the top of the page, there is also the pragmatic reason given by the master, which is that there is no reported case where a bank's customer has recovered damages such as these. That was a claim for £60,000 by way of special damage for the wrongful dishonour of a cheque when no special circumstances were alleged to exist. So, yes, you can claim general damages under your presumption of damage, but that only takes you so far. That allows the court to award a modest sum by way of general damages. But if you want to go further, and bring a larger claim for loss of business, then you need specifically to plead and prove that loss of business to the satisfaction of the court. And appellate courts, it was suggested that we're asking this court to interfere with the wrongful discretion of the judge below when assessing damages. But as we can see from the case law in this area in particular, appellate courts frequently have in the past overturned awards for injury to credit on the grounds that they are excessive. That happened in Rowland and Stewart itself, where the jury's award was reduced by half, and it also happened in Larius and Geraghty. And in both cases, the appeal courts characterized the award below as excessive and outside the boundaries, the permissible boundaries, for the presumed damage. And this court, therefore, can similarly say that this loss was too substantial. My learned friend took your honours to the Jamil case, a case on defamation, and referred to the passage from Lord Scott's judgment at G-014-2019, where Lord Scott said that there was damage presumed in defamation cases because of the difficulties of proving loss. And the point that Bingham made in that same decision, which is the point he makes at paragraph 27, which we have at G-01307, is that while you can make that presumption, and he didn't agree, therefore, he didn't adopt the invitation to abandon that presumption as part of the law of English defamation, he said you can have that presumption, but that is only so long as the presumption is used to keep the award within modest bounds. And we say that echoes precisely the direction of Lord Campbell in Rowland and Stewart. You can presume damage to credit injury in wrongful dishonour cases, but damages must be kept within modest bounds. They cannot be excessive. They must be temperate and reasonable, unless the claimant is going to prove specific loss. And it's for the claimant, if he wants to prove specific loss, to adduce the proper data set and put it before the court to allow the court to assist it. And the difficulty for my learned friend, we say, is that no case, whether in England or elsewhere in the Commonwealth, has ever presumed damages for injury to credit reputation in the order of $10 million, not even close to it. The only sums that have ever been awarded in these cases have been in the range of $25,000 to $425,000 US. And one sees that from the review of the case law that we went to. Now, of course, it is open to this jurisdiction to adopt a different view and to say that it's going to be prepared to presume where facilities are dishonoured by a bank or checks are refused, that there's been much larger damage caused to the customer. But we say that that would be a very dangerous course for this jurisdiction to adopt. There is a risk of creating a very unhelpful precedent because banks and financial institutions may then find themselves met with claims worth millions of dollars whenever they wrongfully decline a check or refuse to extend credit facilities. And in practical terms, that will either lead to a reluctance on banks to make available large lines of credit, or at the very least, it will increase the costs because the banks will want to take out insurance at increased premium as a result of doing business in the jurisdiction in order to cover the risk that it may have to pay out on these types of claims. And we suggest that none of that would be good in the long term for the development of financial business or retail business or trading business within the jurisdiction. So for all those reasons, with great respect, we say that the judge's decision on the damage to reputation is unsustainable. He erred in law because he failed to appreciate in practical terms that the award of $10 million was completely out of kilter with all the other decided cases involving injury to credit reputation. And to the extent that he was trying to award Amira some damages in respect of specific trading losses, he shouldn't have done so unless Amira had sufficiently pleaded and proven that it had suffered those losses. Now, I'm being held very strictly to my pleadings by my learned friend in respect to the counterclaim, and we would respectfully say, what's sauce for the goose is sauce for the gander. He should be held very specifically to his pleadings on the claim of specific loss. And if one looks at those and the particulars that are given, one doesn't see anything put by reference to Mr. Gandhi's schedule. What one sees at most in terms of descending to particularity is the fall in share price value of the parent company, AFNL. And that case was, as the judge found below, convincingly demolished in the trial in the light of the expert evidence. And we say the fallback case, which was unpleaded and came in by way of a late sidewind, by reference to Mr. Gandhi's table, was based on very flimsy evidence indeed. This court is entitled to have regard to that, and to say that to use that as a basis for awarding $10 million is a step too far. Your Honour, subject to anything that my instructing solicitors wanted me to say in addition, I wasn't going to, hold on one moment. Yes, I'm grateful. There is part of the bank's closing submissions that dealt with the unsatisfactory state of evidence on reputational damage. The reference for the court is bundle E, day 3, pages E144, E145, and it starts at line 11 of page 144 of the transcript.
Thank you. Thank you very much, Mr. Masefield. I'll just ask, do my judicial colleagues have any questions for Mr. Masefield? No? No? All right. No. Good, thank you. Well, then I think that concludes the hearing. Obviously, we'll need to consider the helpful submissions that we've received from both counsel and for which we're most grateful. And we'll reserve our decision in order to do so and publish our reasons as soon as we can. So on that basis, the court now adjourns.
Thank you.